Supplementary list, old matter, item number 1.
None appears dismissed.
Supplementary list, old matter, item number 2.
May I please your lordship? My lord, here your lordship, before coming to the case, your lordship,
Yes.
the appellants are the rehabilitated from the Bangladesh from the year 1962.
Okay.
Thereafter, they are settled in different places of the Orissa, like at Malkangiri as well as in Nabarpur district, your lordship. Here, your lordship, after they rehabilitated, a certificate was also issued. Thereafter, this appellant has settled in Parchapara of the Nabarpur district. Now it is Nabarpur district that was earlier in the Korapur district after verification. Thereafter, he is acquiring a one decimal of land. He started a battle shop, your lordship. Thereafter, after bifurcation from the Korapur to Nabarpur, a case was initiated under section 464 of the OPL Act for his eviction. Accordingly, he appeared before this honorable court and filed a writ petition, and this honorable court directed to.
So only ground is that no material to show that he's in possession of the land.
Para 5. That is why the honorable court has declined to express under Article 227. And against the order under Article 227, no appeal is maintainable, as your lordship has already held in many cases.
My humble submission before lordship, they are the refugees, your lordship, since last 1962.
No, they are continuing that beetle shop.
Yes, your lordship.
Then let them continue whatever they continue. Why go through this route then? You withdraw this appeal and pursue other remedies. Because there is no material, so this is 227, appeal not maintainable.
I agree with you, my lord.
Counsel for the appellant seeks leave to withdraw these appeals as they are not prima facie maintainable, but seeks liberty for the appellants to approach the authorities
Protection
for appropriate reliefs in accordance with law.
Protection.
Disposed of is withdrawn with liberty is paid for.
Supplementary list, item number 3.
None appears dismissed.
Should my appearance to opposite parties maybe?
All right.
Supplementary list, item number 4.
Same. 4 also. 5,
6, and 7.
7. Correct. All dismissed.
Obliged.
Right.
Supplementary item number 8.
Same.
Also.
9 also.
Item 9.
9 also.
Item number 10.
Also.
Item number 11.
All right. Till 11.
Supplementary list, old matter, item number 12.
None appears dismissed.
Item number 13.
None appears dismissed.
Item number 14.
Delay. Tell me delay. For 20 days, unexplained. Delay is condoned, not condoned, and therefore dismissed. MC is dismissed and irritable is dismissed.
Supplementary list, item number 15.
None appears dismissed.
Supplementary list, item number 16.
Same one.
Supplementary list, item number 17.
May I please your lordship? My lord, I am passing on a date chart and the list of citations for my lord's kind permission. My lord, in this appeal, the judgment dated 14/9/2016 passed by the learned single judge in OJC number 3657 of 1995 is under challenge. Lord, your lordship, may kindly see the facts of the case. Then I will take a lordship to the judgment passed by the learned single judge. My lord, on 15/1/1974, the present appellant purchased a piece of land measuring an area of acre 0.17 decimals corresponding to plot number 901 of 188 of Khata number 53 on the strength of a registered sale deed for a consideration of rupees 5,000 my lord, from his vendor Rameswar Behra. The land in question, my lord, comes within NSC Titlagar in the district of Balangir. Thereafter, matter after lapse of 10 years, my lord, on 24/3/1984, my lord, Trivikram Behra, who was the son of the vendor of the appellant and the husband of the present respondent number 1 and the father of the respondent number 2, he filed a case under section 23 of the OLR Act before the learned revenue officer Titlagar, stating that as my father belongs to and we belong to scheduled caste, and no permission of revenue officer was taken under section 22 of the Odisha Land Reforms Act. Therefore, this sale is null and void, and he prayed to declare the sale null and void under section 23 of the Act. And accordingly, my lord, the revenue officer, my lord, held that the sale is null and void because no permission was taken from the revenue officer before the sale, my lord. Thereafter, my lord, I carried an appeal before the appellate authority, who is the additional district magistrate Balangir, my lord. The learned additional district magistrate Balangir allowed my appeal, taking into account the law decided by this honorable court, division bench of this honorable court, that the OLR Act is not applicable to the urban homestead land unless by evidence it is shown that it is used for agricultural purpose or accidental, incidental, or auxiliary to agriculture, my lord. And taking into account, my lord, the settlement records, he stated that this is homestead, Gharwari homestead land. It is so recorded in the current settlement in the year 1976, though in the previous settlement in 1936 settlement, it was recorded as, my lord, agricultural land. And taking into account that settlement records, my lord, he held that the sale is not null and void because OLR Act has no application to the urban homestead land as decided by this honorable court. Thereafter, my lord, the present respondents number 1 and 2, the carried a revision to the learned collector Balangir. The learned collector Balangir, my lord, allowed the revision and he upheld the order passed by the learned revenue officer, stating that OLR Act is applicable even to urban homestead land. Thereafter, my lord, the present appellant approached this honorable court in OJC number 3657 of 1995, assailing the order of the learned collector Balangir, my lord. My lord, the learned single judge pronounced the judgment on 14/9/2016, holding that and given a specific finding that the land in question is Gharwari homestead land within the urban area. But, my lord, the learned single judge, due to distortion of facts, my lord, which was neither in the pleadings of the present respondents or which is not even the case, my lord, was misled by the submission that the Titlagar comes under scheduled area, my lord. Your lordship may kindly see page 17, my lord, running page 17, the relevant portion of the, my lord, judgment. Learned counsel for the opposite party number 1, in opposition to the submission of Mr. Saul, learned counsel for the petitioner contended that provision contained in 23 of the OLR Act is not only restricted to non-urban lands, but the Act has also its application to the scheduled area. Since entire Titlagar is coming under the scheduled area, the Act has the application over the disputed land. With great respect, my lord, this distortion of fact has led to the misapplication of law. My lord, your lordship may kindly see, Syria is an area which under Article 244 of the Constitution of India is put in the 5th schedule by way of a presidential order. And, my lord, the Bihar Odisha presidential order, my lord, your lordship may kindly see, that doesn't include Titlagarh or even the Balangir district, and not an inch of Balangir district comes under schedule area. Now, Your Lordship, may kindly come to the finding of the
Single judge.
filing of.
Just
Yes.
come to page 20.
My lord.
It goes on the premise that in the case at hand, there is no dispute that the land is coming within schedule area. This is the problem.
This is
Now,
the this is the problem, my lord, because it was neither the pleading, neither the case, nor it is under schedule
So
area
you say it is not in a schedule area at all.
at all, my lord.
So this is independent of the point that urban homestead is excluded.
My lord.
That's a separate point.
My lord, because in schedule area, any sort of land, my lord, and any alienation, any sale, any transfer is void and illegal, because one cannot take away the property of the tribals. That is the special protection given to the tribals in the schedule area. But not an inch of Titlagarh subdivision in the district of Balangir,
It's in the
and
schedule
even the whole district of Balangir comes under the schedule area. Until
Who's
254
for the other side?
I am for the other.
Huh.
That in fact, that the entire district Balangir is not a schedule area.
Huh.
It is a fact. It is a wrong recording of the fact.
Huh.
But Your Lordship, may I kindly have a glance to paragraph 7.
No, but
You know, that argument has been advanced by them in order to take the advantages of Amarendra Pratap Singh. The learned single judge has not, in order to give protection of Amarendra Pratap Singh, that if some industrial concern is existing over the land, there may be some relaxation. In order to protect that, the learned single judge has given this finding that this is a schedule area. This is not at all a schedule area. But the independent finding is by the revenue officer, no permission accorded for transfer of the property.
where's supposed to permission then? If it is not a schedule area, where's the permission?
My lord, the Whaler Act is applicable throughout the state of Odisha.
No, but these provisions 22, 23 is only for schedule areas.
No.
No,
ma'am.
that is not the fact.
This is for the entire state of Odisha. Your Lordship, may a glance. My learned friend has not properly placed. I am taking Your Lordship to paragraph 22.
The exemption is only section 73C. Your Lordship, may kindly, 73C is the exemption where the permission is not required. That is already explained in the act itself. Section 73C. My counter affidavit may kindly be seen.
So there is no such notification.
Only in that event, the revenue officer can the party can take the benefit of not taking permission from the revenue officer under section 22. 73C.
Act not to apply certain lands.
But Your Lordship, may kindly go through the definitions of the land.
No.
Which
To
is
any area who is the government may from time to time by notification in the official gazette specify as being reserved for urban, non-agricultural or industrial department or for any other specific purpose. Here there is a specific finding that it is not reserved for any urban or non-agricultural purpose. That is number one. The learned courts below, they have recorded a finding that it's cell deed. The kisam of the land, the classification of the land is recorded as in the cell deed. That some Bonnamari or something like that, which is the agricultural land. That is why all the courts below held that the permission is mandatory.
My lord, that point is no more res integra. Your Lordship, may kindly have a glance to the Supreme Court
No,
judgment.
but what is the point about schedule area to do with this then? Why is the judge saying admittedly it's a schedule area when it is not?
It is not a schedule area.
Huh.
It is an area to which section 22 and 23 of the Whaler Act is applicable.
Subject to 73, say exemption in 73.
73, there is no notification issued by the government.
Correct.
That was the stand taken by the government. We have not excluded any area of Titlagarh municipality for application of the Whaler Act. Therefore, in essence, the Whaler Act section 22, 23 is applicable to any area under the municipal limit of Titlagarh municipality. Your Lordship, may kindly have a glance to that judgment. 1999 3 SCC page 231, they have categorically said, observe, the Whaler Act is also applicable to urban area. Your Lordship, paragraph 3 of the judgment.
but with
This is a case from this honorable court. Paragraph 3. In view of the rival submission at bar, the first question that arises for consideration whether the land defined in section 214 of the Act and which is either being used or capable being used as an agricultural purpose within the municipal area does come under the purview of the Whaler Act. The Act, no doubt, is a measure relating to the agrarian reform and land tenure and abolition of intermediary interest. But this provision in the Act which excludes such agricultural land merely because they are situated in the urban agglomeration. The Act applies to land, to all land which is either used or capable being used for agriculture purpose, irrespective of whether it is situated within municipal area or in village.
My lord, with great respect, my lord,
Section 22
the
applies.
facts are different, my lord. Here, the land in question was within the periphery of the Cuttack district in the master plan, which in future has to be included within the municipality area. And this honorable court in this decision, my lord, 1993 Supreme Court has given that land must be used or capable of being used for agricultural purpose, irrespective of the fact whether the said land is situated. And therefore, the conclusion of the High Court on this score is unassailable. But here, my lord, Titlagarh is an NSC since 1951, my lord, since 1954. And Whaler Act came into being in 1960, my lord. And this land, my lord, this state authorities has given permission to the appellant to run a textile bill, my lord. When during the current auction, my lord, at the time of sale, when it was going on, it has been recorded as homestead land. Land and single judge has given the finding that the textile mill is there, and there is no doubt that it is homestead land, and that finding of the land and single judge has not been assailed by my respected senior before your lordships, my lord. Therefore, my lord, this honorable court, your lordship may kindly see the decision, my lord, in Mohri Lal Agarwal's case. I have given, my lord, (43) 1990. 681 and categorically held that, my lord, it is patently clear that a Land Reforms Act did not intend to deal with urban homestead. At para 6, my lord, page 694. Last.
Now there is a Supreme Court judgment saying completely to the contrary.
Yes, my lord. No, my lord, not contrary, my lord.
Om Prakash Agarwal says exactly the opposite.
My lord, no, my lord. Mohri Lal Agarwal also says that even if it is under the urban area and homestead land, but if it is used for agricultural purposes or ancillary to agriculture or auxiliary to agriculture.
No. What Om Prakash Agarwal says is not only used, but capable of being used.
But capable of being used. But now, my lord, that is a textile mill.
No.
Even by the state authorities, my lord. And brings the finding of the single judge, my lord.
My lord,
Please see the judgment.
26 of the brief. Page 26 of
Judgment
the
of
brief.
the judgment of the land and single judge, my lord. Please allow me to complete.
Only fact, page 46 of the brief. The possession has been given to me way back since 18/5/1995. I am in possession.
And status quo is there by this honorable court, my lord. Your lordship may kindly see the paragraph 5 of judgment.
Since 1995,
Please,
they wanted only thing by referring to Amarendra Pratap Singh. They said we have a mill over the property that may be protected. As per the direction of this honorable court, the Tahsildar conducted an inquiry and found there is
Yes.
no mill.
Yes.
The report
There is
is
no.
at page 48.
Page 40.
48 of the writ petition.
My lord,
48.
no, my lord, they are taking this new play at the stage of inter-court appeal.
This is the development I have
My
brought.
lord, your lordship may kindly see the paragraph 5 of the land and single judgment, my lord, page 15. Leaving aside the admitted facts that the land situated within the notified area counts in Titlagarh.
You're referring to a writ petition page or writ appeal?
No, no.
page?
No, my lord, I'm the judgment of the land and single judge.
Read appeal page number
We
48.
don't get 48 here.
Annexure F/2 to the counter affidavit file.
This is my counter
F by 2.
affidavit.
F/2
F/2.
So this is the Tahsildar's inquiry report.
inquiry.
By order of the honorable court, we have
On
submitted
inquiry,
this.
it is ascertained. On inquiry, it is ascertained that now there is no textile mill over the case land, and the recorded land tenant is also not in possession over the case land since around the last 20 years.
My lord, by a judicial order of the land and collector and then by the single judge for the sake of argument, but my lord, if I am not in possession, but how the sale is null and void that is the moot question to be decided in this writ appeal, my lord, because your lordship may kindly see the
All the
finding of the land and single judge in paragraph 5 of the judgment as running page 17, my lord. The land and single judge has categorically held, because my respected senior was, my lord, adverting to the Amarendra Pratap Singh's case. If there is no mean, my lord,
cited.
My lord,
They cited before the learned single.
and my lord, they have not challenged it. Have they challenged this finding and
Because we are
the
in position.
that the single judges and in law by taking resort to the Amarendra Pratap Singh's case, Lord, and let down in this case. And my lord, they have not challenged this finding also, that leaving aside the admitted facts that the land situation within the area of notified area council Titlagar, the petitioner had purchased the disputed land measuring acre 0.17 decimal corresponding to plot number 9011188 in Khata number 53 by registered sale dated 51/1970 from opposite party. The plan for the construction of textile mill for the petitioner was approved by the executive officer of Titlagar NEC in the year 1974.
No, 1 minute. Is your contention that section 22 does not apply at all?
That section 22 doesn't apply to the urban homestead land, my
Where
lord.
do you get that?
If it is,
Where do you get that? Where do you get that?
my lord, because the, my lord, the
Because
definition of the land, my lord,
Om Prakash Agarwal says to the contrary.
Lord, Om Prakash Agarwal says, my lord, it is applicable to the homestead land, whether it is rural or urban, if it is capable of being used.
There is no factory now. The factual finding is there is no factory.
My lord, this is a development.
It has sought
But
to
at the
stop
time of
operating
case, my
for
lord,
the last 20 years.
the appellate court, my lord, the appellate court gave a finding because land revenue officer and collector have not given the
No,
finding.
the report of the Tahsildar, sir.
My lord, my lord, that are going on in spite of the, my lord, status quo order, my lord.
No, that is beside the point. The factual position is it's no longer a factory. That's the factual position.
My lord, no, but factory has been closed, but building is there, my lord. Because of this litigation,
It's a
factory is closed.
dilapidated building, sir. It's not going to be used for factory at all.
My lord, yes, my lord. But my lord, my lord, your lordship, may kindly see the definition of homestead land in 212 of the Act.
No. Where do you find in section 22 that it does not apply to homestead land? Where do you get that? Where in section 22 is
My
any
lord.
provision, any line which says this does not apply
I
to
counter
homestead land?
affidavit at page 7, paragraph 4. Only one line I will show your lordship. Our counter affidavit, page 7. In this writ appeal, we have filed a counter affidavit at paragraph 4.
Yes.
The OLR Act applies to, this is 3rd, 6th, 7th, 8th line.
Yes. To all land.
All land which is either used or capable of being used for agricultural purpose.
This is borrowing from the judgment.
That is referring the case of Om Prakash Agarwal.
Yeah. This is the whole paragraph has been rebooted.
The only exemption is 73C.
My lord,
If-
that 73C is required, my lord, when there is no notification that a particular, my lord, area is either municipality or municipal corporation or NSC notified area council. But your lordship may kindly see the rejoinder and the certificate given by the municipality, my lord, page 9 of my rejoinder annexure 3 or 59 of the running place, my lord, that certified that Titlagar NSC has been constituted by notification number 6397 LSG dated 7/11/1951 of the government of Odisha. So before coming into force of this OLR Act, Titlagar is an NEC. And the 14 notification that my respected senior has, my lord, annexed in the counter affidavit, that is latter development that has NSC has become faulty.
No. Question is, why is this land exempt from the purview of section 22?
Because of the, my lord,
There is only one provision for exemption. There's no notification under 73C saying this land is exempt.
under 73C, my lord, there is no, but 73C,
Unless you have a notification under 73C, the presumption under the act is that it applies to all the lands.
Yes. That is the consistent stand of the government.
my lord, but there is no evidence on record that the land in Coastal being homestead is capable of being used for agricultural purposes.
It's the other way around, sir. You have to show that it is neither agriculture nor capable of being, but factually you've not been able to show that.
Border
The
is
report
on
of the Tahsildar says there is no factory. You went on the presumption that a factory is functioning on that land.
My lord, but the ADM's report, your lordship, may kindly see additional district
That's
magistrate.
the whole problem. So you have a later report of the Tahsildar who goes on the field and finds that
And
it's not there.
Tahsildar report is by virtue of the Honorable Court's order. Honorable Single Judge has directed to conduct the inquiry. during pendency of the writ.
My lord, your lordship may kindly see the land and ADM has categorically held, my lord, during the settlement operation, page 39, running page, my lord, during the settlement operation, the respondents were aware of the proceeding and participated in it, but did not object regarding the recording of the suit land in favor of the appellant, nor did not file any appeal against the order of settlement authority. Thus, said land being homestead land inside the urban area, provision of OLR Act is not applicable. He has given a finding, my lord, that it is homestead land, it is not capable of being used. Thereafter, my lord, again, my lord, during the pendency of all the litigations, my lord, this has been done, my lord.
That finding has been.
And lordship, may kindly said, you go through even the, my lord, 1993 Supreme Court's order, my lord, they have categorically stated that homestead land, even if it is situated in urban area, but if it is capable of being used for agricultural purposes, then the act applies. But it is only if it is urban homestead land, my lord, then, my lord, then Mohri Lal Agrawala will hold the field, my lord. And your lordship, may kindly see, I have given also another decision, 1993 Supreme Court 2585, where the Honorable Supreme Court has said, whatever be the variety of land, how the court has to come to a conclusion that in paragraph 16, my lord, whether it is agricultural or homestead land, and they have given certain, my lord, certain principles, whether the land was classified in the revenue records as agricultural land, whether it was subject to
So
payment
the
of
sale deed, let's look at the sale deed.
Yes,
my lord.
correct. The kisam of the land.
Let's certified copy of the
Agricultural land.
my lord.
It is Atmaram. I'm sorry.
At Mamuli, my lord, it was a kind of agricultural land.
Where are you reading?
Atma Muri, which is
Where
an
are you reading, sir?
counter affidavit, my counter affidavit, page 4, para 3E. Subpara. At the time of sale of kisam of the land was, at the time of sale, kisam of the land was Atma Muri, which is an agricultural land.
Right.
Section 2.2 of the OLR Act defines holding.
It was in the year 1974, my lord, and it was recorded as agricultural land in the year 1936.
That is the best piece of
And no,
evidence.
my lord, at the time of sale, even the settlement process was going on, and that's why an ADM called for the settlement records and given a separate finding that it is homestead land, and even the present respondents did not find any objection for recording of the same as homestead land, my lord. And thereafter, after 10 years of purchase, they filed before the revenue officer that the sale is null and void because we belong to scheduled caste and the purchaser is non-scheduled caste person. Therefore, it violates, my lord, section 22 and 23 of the Act. But without giving a finding that whether the land is an agricultural land or being capable of use, finding, my lord. But the Land and Appellate Court, my lord, he called for the settlement records, all the records from the revenue authorities, and given a finding that it is recorded as homestead land. And this is also the finding of the Land and Single Judge, my lord, that it is a homestead land in urban area. Authorities given him permission to establish a mill.
What is coming in your way is there is nothing in section 22 which says if it is a homestead land, section 22 will not apply.
My lord.
Whereas the judgment says it applies to all lands, whether in a rural area or an urban area.
But if your lordship, my lord, that
So the only criteria is your vendor should be a scheduled caste.
That is admitted. All those things
Your vendor is an SC. If
Yes.
he is an SC, then section 22 seems to apply.
applies. My lord, this is all beneficial legislation to protect the interest of the weaker section of the society. So it is to be strictly implemented, and the scheduled caste person should not be victimized by the non-scheduled community.
My lord, in
That is the
paragraph
intention of the legislation.
1993, even that Om Prakash Agarwal's case, may not, paragraph 3, your lordship, may kindly see. In view of the normal submissions at the bar, the first question that arises for consideration is whether the land as defined in section 240 Act and which is either being used or capable of being used for agricultural purposes within the municipal area does come under the purview of the Orissa Land Reforms Act. But the question was put whether the homestead land is capable of being used for agriculture. Then Land Reform Act applies.
Correct.
Next, there are lots of my lord. they may not go ahead. The act, no doubt, is a measure relating to agrarian reforms and land tenures and abolition of intermediary interest, but there is no provision in the act which excludes such agricultural
That is where,
land.
sir, the report of the Tahsildar becomes crucial for you. That does not support you. To eliminate the possibility of it being used for agricultural purpose, you have to show that there is a factory there.
Yes, there was a factory there, my lord.
Was is different, sir. There is a factory is the question.
My lord,
That was a factory 20 years ago.
My lord,
That's the report. That's a
My
finding.
lord, your lordship has rightly
because
pointed
my
out
lord, my lord,
that
because my
what
lord,
was
during the
the
litigation, my lord,
requirement of law is that at the time of registration of the sale deed, what is the kisam or classification of the land in question? Here, he has described in the sale deed that it is agricultural land. That is the best evidence.
that is according to the 36 settlement, my lord, previous settlement.
Maybe, but that is
No,
your
no, but this
description.
is a 74 sale deed, correct?
74 sale deed, my lord, while the operation was going on.
Ah.
Maybe.
And my lord,
If subsequent
they also participated in the proceeding and did not object of being recorded as homestead, my lord. And your lordship may kindly see,
on the
they-
date of
my
sale
lord,
deed,
my
it
lord,
was agricultural.
my lord, they issued a warrant for taking possession from me. The mill was going on, my lord. This is also the finding of the land and single judge, that the textile mill was going on. Therefore, he said, if that mill is there, according to Amarendra Pratap Singh's, I should compensate them and given the market price value. But with great respect, my lord, when that warrant is there, that warrant was issued, my lord, by a officer to possession of the land. Pursuant to them, my lord, that took possession from me. And thereafter, my lord, I was constrained to, my lord, wind up the mill. My lord, at least, though I, my lord, faced a serious financial hazards, I, my lord, stopped the mill. But, my lord, how, my lord, within the from second settlement records to revenue authorities, from appellate courts, to land and single just finding, my lord, that is all Gharovari. And, my lord, no way, my lord, in their counter affidavit or rejoinder affidavit, they stated. Rather, my lord, they gave this, they, my lord, submitted before the land and single judge. The entire Titlagarh comes under the schedule area. So whether it is homestead
That's a
land.
separate point. That's a separate point. Both of them agree that perhaps the Titlagarh is not in the schedule area.
My lord,
But the question is, your vendor belonged to the SC.
my lord,
Taking prior permission under section 22 was mandatory.
my lord.
And if it did not apply, I mean, it maybe did not apply only to homestead land, which is not capable of being used for agricultural purpose. But here you have not been able to factor in for that.
My lord, the lordship also said, in this view of the matter, we have no hesitation to come to the conclusion that the act applies to all land, my lord. Even Mohrilal Agarwal case says, my lord, that the act applies to all land. Even homestead land of the urban area, if it is being used for agricultural purposes.
Or capable, sir.
Because that is also,
Don't split it up. Used or capable of being used.
My lord, as it is not, my lord, recorded, now the factory has to be, my lord, destroyed. And thereafter, my lord,
There is no factory for 20 years, sir, now. So it is not being used for non-agricultural purpose.
my lord, has he, my lord, taken a stand that the respondents will use it as agricultural purposes, my lord? When they did not object that it should be a homestead land, my lord? They even did not protest. Rather, they, my lord, participated and said that it should be homestead land.
All right. The present appeal is directed against an order dated 14th September 2016, passed by the learned single judge, dismissing the appellates. Red petition OJC number 3657 of 1995, in which the appellant had challenged an order dated 28th January 1994, passed by the collector Balangir, in OLR revision case number 35 of 1986. Full stop. The background facts are that the appellant purchased a piece of land at measuring AC 0.17 decimal, corresponding to plot number 901/1188 of Khata number 53, by way of a registered sale deed from one Sri Rameshwar Behera, who admittedly belonged to the scheduled caste, on 15th January 1974. Full stop. The land in question is situated within the limits of the notified area council (NAC) Titlagarh in Balangir district. Full stop. Admittedly, the kism in the registered sale deed, has been noted by the revenue inspector recorded as Atmamuli, that is an agricultural land. Full stop. Paragraph. The son of the vendor, one Sri Trivikram Behra, who's the husband of respondent 1 and father of respondent 2, filed RMC number 8/35 of 1984 before the revenue officer (RO) Titlagarh under section 23 of the Orissa Land Reforms Act 1960 (OLR Act), contending that since no prior permission was taken from the RO before effecting the sale, the sale deed dated 15 January 1974 was null and full stop. Thereby, section 23 of the OLR Act was invoked. Paragraphs. By an order dated 20th March 1986, the RO allowed the aforementioned RMC 8/35 of 1984, holding that the sale deed in favor of the present appellant was null and void, as it was executed without prior permission of the RO under section 22 of the OLR Act. Paragraph. Aggrieved, the appellant then filed OLR Appeal number 20 of 1986, which came to be allowed by the District ADM Balangir by an order dated 15th October 1986. The ADM observed that the land in question was situated inside an urban area and it was homestead land. Full stop. Accordingly, it was held that the provisions of the OLR Act were not applicable for the purchase of such land by the appellant. Paragraph. The collector Bolangir, exercising the power of revision, OLR revision number 35 1986, set aside the above order of the ADM by an order dated 28 January 1994. Full stop. The collector held that the provisions of sections 22 and 23 of the OLR Act would apply to the land in question, notwithstanding that it may have been recorded as homestead land located within an urban area. Paragraph. Challenging the above order dated 28 January 1994, the appellant filed the aforementioned OGC number 3657 of 1995, which has come to be dismissed by the single judge by the impugned order dated 14 September 2016. Counsel to the appellant informs the court that during the pendency of the writ petition, a status quo order was passed.
Status quo in this writ appeal also.
And that same status quo order was passed as far as in the present writ appeal as well. Paragraph. This court has heard the submissions of learned counsel for the appellant, learned counsel for respondents 1 and 2, and learned AGA for the state. Paragraph. Counsel of the appellant first of all submitted that the observation of the learned single judge that the entire Titlagarh was within a schedule area was erroneous, and since that formed the basis of the impugned judgment of the learned single judge, it was unsustainable in law. Full stop. Secondly, relying on the decisions in Mahurilal Agarwala versus Dusashan Sahu, 43 1977 CLT 681 (DB), Sri Bahanuganga Tribhuvan Dev versus Tahsildar Revenue Officer Sambalpur, 53 1982 CLT 1, and the judgment of the Supreme Court in Srimati CB Muhammad Ibrahim versus Commissioner of Income Tax, Gujarat, AIR 1993 SC 2585. He submitted that since admittedly the land in question was a homestead land within an urban area, the provisions of the OLR Act did not apply, and no prior permission was required to be obtained in terms of section 22 of the OLR Act. Full stop. He submitted that the judgment of the Supreme Court in Om Prakash Agarwala versus Bhattara Behra, 1999 3 SEC 231, which held that the OLR Act would apply to all lands, whether located in a rural area or an urban area, as long as it was being used for agricultural purpose or capable of being used for agricultural purpose would have to be understood in the factual context of the present case, where, according to counsel of the appellant, the land has been recorded subsequent to the sale as homestead land. And in fact, there was a factory of the appellant functioning on the said land. Full stop. In other words, he submits that there is no finding that the land was capable of being used for agricultural purposes. Paragraph.
And it is in the heart of the NAC, my lord.
And that it is in the heart of the NAC. Paragraph. Counsel for respondents 1 and 2, on the other hand, refer to the report of the Tahsildar inquiry report of the Tahsildar dated 28 November 2016, which was submitted pursuant to the order passed by the learned single judge, AC number 3657 of 1995. How is this report 2811? The impugned order is 149.
My lord, that they're subsequently developing in an intra-court appeal, my lord. When there was a singular order, my lord.
This honorable court directed, if they have a factory, let there may be.
No, this court meaning what? Single judge or division?
Single judge.
No, but single judge disposed of the petition in 14-9.
49.
But this report is 2811.
Yes, ma'am. I am explaining. On 49, this honorable court disposed of the writ application by saying, the revenue officer may conduct an inquiry. If it will be found a factory is existing, then that factory may be kept in intact. They may pay compensation to the landowner, to the SC, to the present respondent. Accordingly, the revenue officer directed the Tahsildar to conduct an inquiry and to submit a report whether a factory is existing as on today, so that it can be intact, remain intact.
Right.
And the Tahsildar gave a report, made an inspection, and made a report that there is no existence.
I know. I just wanted to know how this report is dated later than the impugned order.
And this is pursuant to the final order.
Final
Yeah,
order.
My lord, final order status quo was thereafter, my lord, granted by this honorable court
It's
division.
all right, sir. It's all right.
All right.
It is submitted that in terms of the said report, it is plain that at present, and even at the time of the said inspection, there was no textile mill over the land in question. And the tenant was also not in possession of the land for over 20 years. He submitted that possession, in fact, has now been handed over to respondents 1 and 2, and they continue to remain in possession of the land in question. Paragraph. Mr. D.K. Mantri, learned AGA, referred to the counter affidavit filed, in particular to the averments in para 3 bracket capital E, which refers to the aforementioned report, which refers to the fact to the order of the revisional authority and the finding therein that the kism of the land was agricultural at the time of the sale deed. Full stop. It is submitted that unless there is a notification of the state government under section 73 bracket small c of the OLR Act, exempting the land in question from the applicability thereof, the provisions of the OLR Act will continue to apply to the land in question. Full stop. It must be noted here that both the counsel appearing for respondents 1 and 2, as well as the learned AGA, did not dispute the fact that the learned single judge perhaps erred in observing that the entire Titlagarh was a scheduled area. It is submitted that, in fact, it is not a scheduled area, but that would make no difference to the applicability of sections 22 and 23 of the OLR Act to the land in question, inasmuch as the vendor of the present appellate belonged to the SC. Paragraph. The above submissions have been considered. Stop. The plain reading of sections 22 and 23 of the OLR Act do not indicate that any exemption is made from its applicability to a land, to a homestead land located within an urban area. Full stop. This position becomes clear when read with Section 73 of the OLR Act, which reads as under. As pointed out by the learned AGA, in the present case, there is no notification issued exempting the land in question from the applicability of the OLR Act, only because it is located in an urban agglomeration. Paragraph. Turning now to the decision in Om Prakash Agarwal versus Batara Behra Supra, the court finds that the following observations in para 3 of the said judgment are relevant for the purposes of the present case. Then reproduce para 3. Paragraph. It is plain, therefore, in terms of the above decision, the OLR Act would apply open quotation to all land which is either used or capable of being used for agricultural purposes, irrespective of whether it is situated within a municipal area or villages, unquote. In other words, merely because the land is within the NAC of Titlagarh would not exclude it from the applicability of the OLR Act, as long as it is shown that it is either being used or capable of being used for agricultural purposes. Paragraph. Counsel for the appellant vehemently contended that since a textile factory was being operated on the land in question by the appellant for long, there is no finding that the land is open quotation capable of being used for agricultural purposes, unquote. Full stop. It is seen that while delivering the impugned judgment, the learned single judge in the operative portion issued the following directions. Para 10, page 7, paragraph. Pursuant to the above directions in the impugned order, the Tahsildar undertook the exercise of determining what the current status of the land was. Full stop. Tahsildar, in a report dated 28/11/2016, came to the following findings. Inter alia came to the following finding. Just take page 27, first paragraph. The factual situation, therefore, is that there is now no textile mill over the land in question, and the appellant is also not land. Full stop. It is therefore not possible to accept the plea of the appellant that factually it has been shown that the land in question is not capable of being used for agricultural purposes. Paragraph. This court has perused the decisions in Mahurilal Agarwala, Supra, Shri Bhanuganga Tribhuvan Dev, Supra, and the judgment of the Supreme Court of India in Srimati Sarifa Bibi Muhammad Ibrahim, Supra. Stop. As far as the last mentioned decision is concerned, it was not in the context of the OLR Act. Full stop. It was in the context of the Bombay Tenancy and Agricultural Lands Act. Full stop. Further, the question that was being addressed by the court arose under the Income Tax Act, 1961. Full stop. Consequently, the court finds that the said decision is distinguishable since questions regarding the nature of the land and the restrictions on transferability have to be addressed in terms of the local law, which in this case is the OLR Act. Paragraph. As far as the decision in Mahurilal Agarwala is concerned, it is seen that it is a decision of the division bench of this court dated 10th May 1977. And whereas the decision of the Supreme Court in Om Prakash Agarwal, Supra, is dated 10th March 1999 and would obviously prevail over the decision of this court. Stop. Likewise, the decision of this court in Sri Bhanuganga Tribhuvan Dev, Supra, has to be read now in the context of the subsequent decision of the Supreme Court in Om Prakash Agarwala, which is the relevant portion of which has been extracted here and before. Paragraph. Since the law in question is governed by the decision in Om Prakash Agarwal Supra, the court has no hesitation in holding that in the present case, there is no escape the applicability of sections 22 and 23 of the OLR Act to the land in question. Paragraph. This is irrespective of the fact that the learned single judge may not have been correct in observing that the entire Tetlagad area would be a scheduled area within the meaning of the OLR Act. Full stop. Irrespective of that, it is plain that section 22 and 23 of the OLR Act does apply to the land in question. And inasmuch as prior permission was not obtained at the time of execution of the sale deed in favor of the appellant, it was unsustainable in law. Paragraph. For the aforementioned reasons, the court finds no grounds to interfere with the impugned judgment of the learned single judge. The appeal is dismissed. The interim order stands appealed.
Well, that operative pass has to be carried out by the authorities regarding compensation, my lord.
Yes, yes. The operative directions of the learned single judge as regards compensation payable to the present appellant would have to be carried out in accordance with law, now that the report of the Tahsildar is already available.
Because they are given the factory on rent, my lord. That is also
anyway, that's for them to decide. All right.
Yes, only one thing. In taking into consideration the Tahsildar report, because
I have already said that, sir.
That is already written.
Item
Supplementary list
item
18.
16, my lord. I beg apology for not
16.
I beg apology for not appearing of the item. I pray that item may be taken up after lunch, my lord. Item 16, 16.
All right.
Oh, bless.
Item number 18.
May it please your lordship. Lord, I am in dissimilar. Here, my lord, the petitioner is a, my lord, landless and a homesteadless person. And he is also, my lord, having suffering from leprosy of 60%, for which he is outcasted and is staying in a land over the government land last 20 years. And as per, my lord, section 7(2) of the OPLE Act, though the same land should have been settled in his favor, but several notices being issued for evicting him from the settled land. And he has challenged those notices. And the Honorable Single Judge held that as this petitioner has been given to notice.
Why don't you read, sir? Instead of summarizing, you read it.
My lord, I am Order, my lord. I had learned counsel for the petitioner. This is a matter apprehending eviction of the petitioner at the instance of the public authority. In filing the writ petition, petitioner has alleged that no proceeding has been initiated against the petitioner involving the disputed land, and the public authority is going to evict the petitioner without following due process of law. Considering the submission made herein and after perusal of the documents under Annex 3 series, this court finds two separate enforcement proceedings involving two patches of land illegally encroached by the petitioner, and the proceeding have not been initiated against the petitioner, but the petitioner, after being found to be an encroacher in respect of the above lands, has even accepted the decision in the compliance thereof fine and deposited the fine amount as appearing in the receipt by the annexure by page 17 and 18 to the writ petition. Accordingly, there is no doubt that petitioner is admittedly an encroacher, and there is no dispute that the enforcement proceeding have been already been initiated and decided against the petitioner, and the petitioner has not challenged the same. Under the circumstance, this court does not find any merit in the writ petition, and accordingly, the writ petition stands dismissing no merit. My humble submission here before your lordship is that the section 7(2), your lordship can have a glance over the same. 7(2) of the OPLE Act. My lord, I am just reading for your lordship.
First, you make your submission, sir.
My lord.
Kindly make your submission and then we will read the provision.
My lord, my lord. My lord, here, though, my lord, the petitioner is admittedly a landless person and having 60% leprosy, and I have annexed, my lord, document in the writ petition. And also, my lord, I have given that notice that those two encroachment proceeding was initiated and a notice was served and this person has the rent, paid the Milord fine. But as per 7.2, when the authority find that this person is a landless and homesteadless persons, the law provides that should have been settled instead of evicting that person from that land.
Sorry. What is it? What is the submission? That he, despite finding he's an encroacher, land should be settled.
Settle, Milord, if he is a landless and homesteadless person.
That's what the section says.
Milord, that's it.
No. In an
let's read that.
encroachment proceeding, they should have come forward with another proceeding under section 7 for settlement of the land. Found that he is a landless person. But so far as encroachment proceeding is concerned, that is an independent
Separate
proceeding. That is a separate proceeding. Has he applied for settlement? If he has applied for, then it will be taken up in accordance with law.
No, Milord, there is no such provision is there. My learned friend is saying that it's a separate thing and which is aligned to Milord the law. I do not know where it is. Your Lordship can have a glance that
7.2b. I think he wants to see 7.2b.
7.2b.
Milord, 7.2, I'm just reading Milord.
Where any land is in the unauthorized occupation.
Milord.
7.2b, sir.
Yes.
Milord, where any land is in unauthorized occupation of a homesteadless person which is being utilized by him as homestead, the Tahsildar shall, your Lordship may say the man, the Tahsildar shall, instead of evicting such person, settle the same with him. So, however, that the land so settled with him shall not exceed 1/10 of an acre. Milord.
Where is the impugned order of the Tahsildar? Under which you are being removed. Where is that encroachment order in the encroachment case?
They have issued encroachment, your Lordship, page 18 of the page 16 and 16, 17, 18, Milord, your Lordship, of the writ petition.
18.
18.
What is that? Some slips, 16, 17, 18 are simply some slips, sir.
My lords, those are the, my lord, the penalty that has been imposed after the final order the petitioners. This petitioner has paid all those penalty, my lord. My lord, where the Tahsildar is finding that this person is a landless and homesteadless person, and more particularly, my lord, he is being 60%.
No. What is that to show your homesteadless? These slips are there for unauthorizedly occupying a land.
Occupying, my lord, government land.
No, but what is there to show that you do not have any land?
My lord, I do not have any land, my lord, as stated, and this person, my lord, your lordship.
No, your stating is one thing, sir. What is
page 15? Page 15. That leprosy certificate I have given, my lord, that person is 60% leprosy.
No. What is that to show you do not have land? Doesn't mean people with leprosy do not possess land. Where's there's no such presumption, sir, that a person with leprosy does not have land. What is that to do with not having land?
My lord, I have taken stand, my lord, I have no land, and they have inquired also, my lord, that there is no such finding that I have any land. That's why, my lord, they have rejected. There is no such finding to that effect.
That is why your lordship is asking where is the order of the Tahsildar.
That's right. Where is that order?
My lord, that order
in the encroachment case. Where is the order in the encroachment case?
That order that was not encroachment.
No. How else will you demonstrate that there is a finding in that regard?
Your lordship might keep another.
No, the only thing is you make an application now afresh.
Correct.
Yes, your lordship may say that.
You say the contention of the counsel for the appellant is that while passing an order against the appellant in the encroachment case, the authority in question ought to have noticed that he is a person without any homestead land and should have applied the provisions of section 7 bracket 2 bracket small b of the Prevention of Land Encroachment Act 1972 bracket OPLE Act paragraph. Unfortunately for the appellant, the order of the authority in the encroachment case has not been enclosed either with the writ petition or even the present writ appeal. Therefore, the court is unable to appreciate whether the above factor was in fact taken note of by the authority in question. Be that as it may, if in fact, if the order of the authority in the encroachment case does not advert to section 7 bracket 2 bracket small b of the OPLE Act, it would be open to the appellant to initiate separate proceedings in that regard in accordance with law. With the above observations, the writ appeal is disposed of.
Supplementary list item 19.
My pleasure, my lord. Here, my lord, in the appeal, the appellant's fact of the case, my lord, the ROR stands in the name of the father of the appellant, my lord, under annexure 1, my lord. On the strength of a Seba Samarpana Patra, the respondent number 3 was given a do the Seva Puja of the DT. On that basis, my lord, a mutation case was filed by the opposite respondent number 3, and the record was corrected in the mutation proceeding. That was challenged by the appellant in the mutation appeal before the sub-collector.
What is the impugned order, sir?
My lord, impugned order, my lord, here.
And that you have an alternative remedy of an appeal.
No, my lord, that is what, my lord, my submission is. My lord, the order of the mutation order was set aside. Thereafter, my lord, the Tahsildar, instead of restoring the ROR in the name of the appellant, my lord, has to record the same in the name of the respondent number 3. That was my grievance.
Is subject to an appeal, sir.
My lord,
What the single judge is pointing out, that order, the Tahsildar, is subject to appeal.
my lord, that order, the Tahsildar order, your lordship may kindly see order of the Tahsildar under annexure 6, my lord. Tahsildar has dropped the proceeding.
So whatever, sir, some order is there.
No, my lord, he has, my lord, your lordship may kindly see. Tahsildar has dropped the proceeding, saying that the mutation proceeding is dropped till the disposal of the civil suit. And his earlier order of mutation in favor of the respondent number 3 was set aside by in the appeal. My grievance is, my lord, I prayed for restoration of my ROR in the original tenant, name of the original tenant. That is not being done, my lord. My grievance is that, my lord.
So in the writ petition, what did you challenge?
My lord, in the writ petition, I have challenged the action of the Tahsildar in not restoring the...
What is the action meaning what? Some order?
My lord, so far as the order is concerned, my lord, Tahsildar initially mutated the land in the name of the respondent number 3. Thereafter, mutation appeal, the order of the mutation was set aside, and it was remanded to the Tahsildar for fresh adjudication. Then I made an application before the Tahsildar that you restore the ROR in the original lessee name. He has not done that. Against that, I came up in the writ application. And this honorable court in the writ application, previous writ application.
No, what you challenged in the writ petition, just let's go to the prayers in your writ petition. That
my prayer in the writ application to restore the ROR in the name of the original lessee.
Now, that restoration is denied by the Tahsildar. So, necessarily you have challenged the order of the Tahsildar. It is amenable to appellate forum. That is the finding of the
your lordship will find, my lord, in the mutation appeal, only final order of the Tahsildar can be challenged, my lord. Here, my lord, he has dropped the proceeding. He has dropped the proceeding. Your lordship may kindly see
petition, sir.
Page 27.
Page 27 of read the prayer. Read the prayer in your writ petition.
Writ petition, my lord. My lord, the petitioner therefore pays that this honorable court may be allow the writ petition with a direction to the opposite party to cancel the corrected ROR at annexure 5 and restore annexure 1 to the land records standing in the name of Ghana Rao within such period as the honorable court may like to indicate, and with further direction to the opposite party number 2 not to proceed further in the remanded mutation case number so and so until annexure 1 is restored to the land record, my lord.
No, the remanded mutation, who passed that order for remanded mutation?
My lord, sub-collector passed in the appeal.
No.
In the appeal.
Remanded mutation, Tahsildar passed.
No.
After the remand, your lordship, I am giving the...
Collector passed the remanded mutation order.
No. On that, the Tahsildar passed an order or not?
No, that, my lord, your lordship may kindly see. Tahsildar thereafter dropped the proceeding saying that civil suit is pending.
Exactly.
I will not...
That is what it is not saying.
Order dropping the proceeding is an appealable order, sir.
That is what...
My lord, I am not aggrieved by that order, my lord.
Then,
of course you are. Of course, you are aggrieved. You are
No, no,
saying-
prior to that,
waiting for civil
my lord, prior to that,
Page
the order,
27.
my lord, I may be permitted, my lord, I'm just satisfying your lordship. Prior to that, the sub-collector has set aside the earlier order of mutation.
and
That
sent
is-
it back to the
therefore-
Tahsildar, sir.
Therefore, the Tahsildar is
back
under
to the
obligation
Tahsildar.
to correct the error.
Whatever the Tahsildar does, he has to pass some order saying, because a civil suit is pending, I'm not proceeding.
My lord, may kindly see the order of the Tahsildar.
Outcome of the civil suit.
Yes, my lord.
Ah,
Yes, my lord,
that order is you're agreed by.
my lord, I'm placing the order of the Tahsildar, my lord. Your lordship may kindly see.
He is missing a link.
Page 27.
Page 25, your
Page
lordship.
27. I'm coming to
But
that.
that is most important. The order of the honorable court in a previous writ petition.
Yes, my lord. Yes, my lord.
That is, he is not pressing.
No,
that.
no, I'm also relying on my lord. Your lordship may kindly see page 25. What is the order of honorable single judge in earlier rate application? This court finds ample force on the submission of the learned counsel for the petitioner. Since the matter is remitted back to the Tahsildar Ali for de novo inquiry, the ROR shall not be given effect to. The Tahsildar Ali is directed to conclude the hearing of the case within a period of 3 months from the date of production of a certified copy of this order, my lord. Thereafter, my lord, he continues to, my lord, the same ROR, corrected ROR, despite of the order of this honorable court. Your lordship may kindly see
No.
order of page 27.
That's right. This is a final order, sir.
Yes, my lord. Your lordship may the learned counsel,
Position the case, this court doth hereby pass an order that the case is dropped.
my lord.
So
The
which show-
previous para. Your lordship may kindly peruse the previous para.
Yes, yes.
The learned advocate on behalf of the opposite party urged to restore the status of the ROR of the Suitland as it was earlier,
All right.
prior to the mutation case number so and so.
All right.
As the mutation case is set aside by the sub-collector Kendrapada.
All right.
So he is supposed to restore to its original ROR.
All right.
But that has not been done. Therefore, my lord, my grievance is independent. And this is not a final order so that appeal can lie, my lord.
It is.
Only-
It is. Sorry, we don't agree with you on that.
My lord.
You say the challenge
lord,
to the present
in-
appeal
my
is
lord, may I-
dated 19/10/2016, passed by the learned single judge dismissing the appellants. Writ petition civil 17794 of 2016 on the ground that there was an alternative efficacious statutory remedy of an appeal against the order dated 11th March 2016 passed by the Tahsildar. Sorry, against the order dated 23rd July 2016 passed by the Tahsildar, declining to proceed with the matter in view of the dropping the proceedings in view of the pendency of a suit CS number 10/16 in the civil court. Paragraph. Having heard the learned counsel of the parties, the court is satisfied that the aforementioned order dated 23rd July 2016 of the Tahsildar is in fact of a final nature and is an appealable one under the OLR Act.
No, under the mutation
Mutation
manual.
manual.
Under the
Section
mutation
mutation
manual.
Rule 90 of mutation manual.
Under Rule 92 of the mutation manual. Consequently, the court finds no error having been committed by the learned single judge, which requires interference by this court.
My lord, liberty may be given to file the appeal, my lord. Because 6
is-
years in the meantime have been elapsed, my
If
lord.
the appeal is filed not later than December 2022, then the explanation offered for the delay on account of the pendency of the writ petition as well as writ appeal will be taken into account by the appellate authority in accordance with law.
Obliged, my lord, obliged.
Supplementary list item number 20.
May I please, your lordship? A delay is 1 year, but the appeal involves with regard to claim for promotion from the date the juniors have been promoted.
Huh?
Writ petition was disposed
Sir,
of.
there's some wrong calculation in the way you understand delay, sir. Our office has understood as 1832 days.
My lord,
A slight difference between 6 years and 1 year, sir.
my lord, 2015 the order was passed and 2016 it has been filed, my lord.
I don't know.
My lord, it can't be, my lord. If it is my 7/8/2015, your lordship, the order was passed.
Even then, even one delay is a lot of delay, sir.
I leave it to
Service
your
matter. There's a delay of over 1 year in filing the present writ appeal. The explanation offered for the delay is not satisfactory. Consequently, MC number 844 of 2016 is dismissed. As a result, the writ appeal is dismissed. All right.
Obliged.
Item 21.
None appears dismissed.
Item number 22.
Item 22, I pray for tomorrow, madam.
What is the matter about, madam? Let's just see. No.
Today I am not ready, so that's why I.
Let's read it with you. So we'll see how difficult it is to understand.
Appeal is filing challenging the order passed by learned single judge on the ground that without expressing any opinion on the finding of the learned lower court and without discussing the evidence on record and without appreciating legal position, learned single judge has passed the order directing the opposite party to file the return.
No, it's just a remand.
It is a remand
Madam,
order.
It's only a remand order.
It is only
Para
a
13.
remand order.
Yes, my lord. That is the order.
Ah.
And
Nothing, no harm in that.
opposite party is directed to file the return before the.
Yes. By now, the order must have been
Yes, that
implemented.
is also to
There's
be
no stay in
verified
this.
there is no stay for
No
last
stay.
The
6
challenge in
years.
the present writ appeal is to an order dated 19th October 2016 passed by the learned single judge disposing of writ petition civil 20040 of 2014 filed by the present appellant. A perusal of the imperial order reveals that all that the learned single judge has done is to remand the matter to the original authority, with the direction to both parties to appear before the original authority in RMC number 14 of 2007. Stop. During the pendency of the writ appeal, there has been no stay of the said order. It ought to have been worked out by now. In any event, the court is unable to find any error having been committed by the learned single judge that calls for interference. The writ appeal is dismissed.
Item 23.
None appears dismissed.
Item number 24.
Same order.
Item number 25.
May I please, your lordship? On behalf of Mr. Bose, kindly taken up next week, my lord.
No, we're not adjourning like this. Please.
Mr. Bose is not available to.
No, please ask him to be available. We're not adjourning it. Yes.
Kindly pass over. I'll-
Yes, pass over.
Item number 26.
Item number 26, my lord, this is state's appeal. There is a delay of 522 days.
522 days not properly explained. Dismissed.
And another request, ma'am, I'm sorry that item number 14 I could not come. That will be dismissed, but that non-appearance has been lettered. Instead of that, on the ground of delay, because that is also 511.
All right. 500 days delay, so that's dismissed. All right.
Great. Item number 27.
No. 27. Correct.
27.
None appears dismissed.
Item number 28.
None appears dismissed.
Item number 29.
And this is not maintainable. I am for the respondent arises out of a suit.
I see. Anyway, none appears dismissed. All right.
Supplementary item 30.
None appears dismissed.
Item number 31.
None appears dismissed.
Item number 32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
None appears dismissed.
Item number 35.
My lord, 35, my lord. Mr. Mohapatra, Manas Mahapatra will argue the matter. He is out of station. So
that's not the way to treat us.
So
you can't have an appeal coming up in the High Court and you go off auto station. We're not adjourning on these grounds.
It was listed for first time because
we're not adjourning on these grounds, sir. This is the High Court. You'll have to give some priority to matters in the High Court.
That's my lord. So he has to argue. He has to argue. So kindly accommodate him because one day, any day, my lord, any day. Not for today, any day.
No.
Senior.
We'll pass it over. Why don't you get ready with the matter? You can easily argue these matters. Pass over. You argue matter. Pass over.
Item number 36. 36.
None appears dismissed.
Item number 37.
Item 37, Mr. Pikare undergone eye operation and he just suffer accommodation. So it takes
37.
some time. 37.
All right, counsel for the appellant is stated to be unwell. The list on 14 November.
Item number 38.
May I please, Lord? Here, my lord, the order of the honorable single judge is at page 18, my lord. Direction was given.
335 days delay, sir. There's a delay of 335 days in filing the
May I
appeal.
pray, Lordship, and dispose of in one, my lord. It has become infectious to some extent because he was praying for correction of date of birth. He was praying that it should be declared as 60 instead of 56. So during the pendency of the writ application, in any case, 4 years have passed. The Lordship may say that it has become infectious.
All right, counsel for the appellant states that the appeal has become infructuous. It is disposed of as such.
May I pray, Lordship may not record. Lordship may say, my lord.
No, they can't have it both ways, sir.
The Lordship may dismiss on the ground
Delay.
of limits.
Yeah, there's an unexplained delay of 3 days.
Item number 39.
Delay.
It's similar to the
1 year.
1 day.
1 day.
One
All
day.
right, delay is condoned. Yes, tell us.
Petitioner's son died during immersion of Lord Ganesh in the school pond. And compensation, pays for compensation, approach the authority. Lord Single Judge has dismissed this writ application. It's not inclined to how the responsibility or negligence should get attributed to them who indicate to place on a holiday. That way, as per the instruction or direction of the school authority, not even their presence. That's not, counter has not been filed in this writ application. But they're saying this since it was a holiday, that cannot be considered.
Yeah, it was not. Main thing, sir, this immersion doesn't take place at the direction of the school authority.
Yes, ma'am. Because in their presence, they have also granted that is the headmaster admitted, my lord, and I have been paid for this reason. My lord, the collector has paid 10,000 for.
That's all ex gratia, sir. When you come in a writ petition, when you're seeking compensation, you'll have to say that there was a failure of a constitutional duty.
Yes, my lord. The school headmaster admitting this position, my lord.
What admitting?
But they have opened the school, and that was
on a holiday, sir, for immersion. It's not. This is not a school's there. It's not a school function. Come to page 14.
Yes, my lord. That's there. I have seen, my lord. That is the findings. But no counter was there.
No, on a holiday, they're just opening up the school pond. That's it. It's a public function in the school pond. It's happening. That's all.
And in presence of the, my lord,
you can't hold the school authority responsible.
Yes, my lord, in presence of the school authorities, my lord.
Presence of is not the same thing, sir. Everybody goes for a puja. In a holiday, even a headmaster will be present for the puja. Doesn't mean that he's directing the students to perform it.
Now, answer 2 is the headmaster, my lord.
Correct. He says he is present. Ex gratia has been awarded.
Lord,
there has to be some responsibility which has not been discharged by the school authority. Then you can fix liability. Not for these kind of things. You say the challenge of the present writ appeal is to an order dated 9th January 2017, passed by the learned single judge, dismissing writ petition civil 13273 of 2012, filed by the present appellant, whose son was studying in class 10 of the Baya Abadhuta High School, Kanimur, in Jagat Singhpur district. Died on 2nd September 2011 during immersion of the idol of Lord Ganesh in the pond of school. Paragraph. As noted by the learned single judge, the immersion of the idol in the school pond took place on a holiday, and it was not under the direction of the school authority or any of the teacher or staff of the school. Full stop. In view of the above factual background, it was not possible for the appellant to demonstrate any failure of discharge of official function by the school authorities warranting fixation of liability on them for the unfortunate death of the appellant's son. The court is unable to take a different view than that taken by the single judge in the matter. The appeal is accordingly dismissed.
Item number 40.
None appears dismissed.
Item 41.
41, no instruction, man. No instructions dismissed.
Item 42.
None dismissed.
Item number 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item number 45.
My lord, item number 45 to my lord, item number 48. 4 matters, my lord, it's a batch of matter along with few others. My lord, I'm led by a senior, my lord, if it can be taken up some other day along with the other 3, my lord.
What's the matter about then? The other 3 will follow what we're deciding here today.
So the batch is around 40-50 matters are filed. Keep the list, my lord, let it.
No, but tell us what the matter is, sir. Once we decide this batch,
is with regard to
will follow.
This is with regard to the motor vehicle tax, which the dealer has to pay for keeping the vehicle. The court single judge has decided, no, we have to pay as per the vehicle, each vehicle. But we are filed this appeal, my lord. There's a provision that has not been taken care of.
Show us all that.
Yes. The Rule 7.
Motor Vehicle Act.
Yes, Rule 7 of Odisha Motor Vehicle Taxation Act.
Motor Vehicle Tax. Where is that provision? Show us. Where is the main judgment, sir? 5648 of 2017. That must be set out in the impugn judgment.
The Rule 7 says the maximum number of vehicle kept with the vehicle with the dealer at any point of time, for that he has to pay tax, my lord.
Correct.
But the single judge decided, no, the number of vehicle he has sold in a year, for that he has to pay tax. That is the, my lord, that is.
So let's read it, sir.
My lord.
Let's read the judgment. It's there. Internal page 4, para 4. Actually, discussion starts in para 10. You can read from para 10 of the orders. For just and proper adjudication.
Yes, 43.
Page 10.
All provisions have been set out in the judgment itself.
Your lordship, that rule is quoted at page internal page 17, page 50.
Yes.
The section 5 shall submit a declaration in plain paper stating legibly therein category wise make and model of the vehicles and the maximum thereof for which the additional tax is being paid, and certified the maximum number has been never been exceeded at any point of time during the previous quarters. But that is to say, my lord, if the vehicle, my lord, the dealer is, my lord, 100 vehicles per month, my lord, but he has kept the minimum stock he is keeping 50. Every time, each month, my lord, that stock will not exceed 50. He may be selling 500 vehicles per year, my lord, but his stock must not exceed 50. For that, he has to pay tax, section 5 of the Odisha Motor Vehicle Taxation Act. But here, my lord, the Lord Single Judge.
Let's discuss, sir. We not without reading or only summarizing. Let us read.
My lord.
what he has said, what the single judge has said, let us read it.
My lord.
Para 11.
Page 52.
Why did one of you read para 11, please?
May I read, my lord? The members of the petition trust, being the dealers within the meaning of Section 28 of the Motor Vehicles Act 1988, are engaged in the business of hypothecation, leasing, and hire purchase of motor vehicles. In view of the provisions contained in Section 39 of the Motor Vehicle Act 1988, no person shall drive any vehicle, and no owner of a motor vehicle shall cause or permit the vehicle to be driven in any public place or any other place unless the vehicle is registered and the certificate of registration of the vehicle has not been suspended or cancelled, and the vehicle carries a registration mark displayed in the prescribed manner. Thereby, the registration has been imposed with regard to the plying of the vehicle without any registration number by any person or even owner of a vehicle in a public place. But the proviso to Section 39 authorize a dealer who is in possession of a vehicle to ply a vehicle without registration subject to conditions as prescribed by the central government. In other words, therefore, the restriction imposed by the ply of a vehicle by a person or a owner is not applicable to a dealer who possesses a motor vehicle subject to conditions prescribed by the central government without any registration. The motor vehicle cannot be driven or caused to be driven or caused to be used in any public place or any other place for any other parties indicated therein without requisite registration. The Section 40 thereof deals with the registration where to be made, and Section 41 deals with the registration how to be made. Section 42 deals with the special provision for registration of the motor vehicles diplomatic officer, where the Section 43 deals with the temporary registration, and for Section 44 deals with the production of vehicle at the time of registration. Section 45 deals with the refusal of registration or renewal of certificate of registration. Section 191 deals with the sales of vehicles in or alternation of vehicle in condition contravention of the Act. In any dealer contravention Chapter 7 or any rule made thereunder shall be punishable with a fine which may extend 100 rupees. Section 122 deals with the using vehicles without registration, which clearly specifies that whoever drives a motor vehicle or causes or allows a motor vehicle to be used in contravention of the provisions of Section 39 shall be punishable as per the provisions mentioned therein. The Chapter 3 of the Central Motor Vehicle Rules 1989 deals with the registration of a motor vehicle. Under the subheading Trade Certificate, Rule 33 puts a condition for exemption of registration as per the proviso to Section 39, which provides that if a motor vehicle is in possession of a dealer, manufacturer shall be exempted from necessity of registration, subject to condition that he obtains a trade certificate from the registering authority having jurisdiction in the area as his place of business in accordance with the provisions of this chapter. Rule 34 deals with the trade certificate, which specifically provides that the application for grant of renewal of a trade certificate shall be made in Form 16 appended to the rules. Clause 5 of Rule Form 16 clearly states that the number of certificates required, meaning thereby an application is to be submitted by a dealer to a registering authority concerned. He has to furnish detailed information as prescribed in Form 16. In addition to the same, prescribe the number of certificates required for him, and the same has to be made by way of a declaration. Therefore, the trade certificate has to be granted on the basis of application submitted by the dealer, requiring him to provide the number of certificate to be granted by the registering authority for the purpose of trade certificate. On consideration of the said application in Form 16, under the Rule 34 of the registering authority, in turn granted a form trade certificate in Form 17. Rule 35(1), where it is specified that serial number 1, the serial number of certificate at serial number 2, the full name and address of the certificate holder. The validity of trade certificate granted under Rule 35 shall be in force for a period of 12 months from the date of issue or renewal thereof, shall be effective throughout India as per the provisions of Rule 37, and Rule 39 clearly speaks about use of trade certificate registration mark number shall not be used upon more than one vehicle at a time or upon any vehicle other than the vehicle bona fide in possession of the dealer in course of his business, or any type of vehicle other than the one for which the trade certificate is issued. Rule 41 clearly provides that the holder of a trade certificate shall not use any vehicle in public place under the certificate for any purpose other than the condition as to A to H. The said conditions are in consonance with the provisions contained in proviso to section 39 of the Motor Vehicle Act 1988, read with rule 33 of the rules 1989, except for the conditions stipulated in clause A to H in rule 41. The dealer cannot ply a vehicle in a public place under the trade certificate issued in his favor by the registering authority. Rule 42 states that no holder of a trade certificate shall deliver a motor vehicle to a purchaser without registration, whenever whether temporary or permanent, as the case may be. And every dealer shall maintain a register of trade certificate under the prescribed form 19 and under rule 43 of the rules 1989. In the said form 19, the dealer has to maintain the register giving details particular of the vehicle purpose for sale out or brought, which should be in the consonance with the conditions stipulated in clause A to H of rule 41 of the rules 1989. The said trade certificate can be suspended, cancelled after giving opportunity of hearing under rule 44, against which the order appeal lies rule 45. Rule 46 and the procedure has been envisaged under rule 46. Under chapter 3 of the subheading registration, rule 47 states about the application for registration of a motor vehicle, in which an application for registration of a motor vehicle shall be made in form 20, to which the registering authority within the period 7 days from the date of taking delivery of such vehicle, excluding the period of journey, and shall be accompanied by a sales certificate in form 21, and along with the other documents as enumerated in subclause A to K of rule 47 of the rule 1989. The sales certificate issued in prescribed form number 21 clearly states that the same should be issued by a dealer along with the application for registration of a motor vehicle, with an endorsement that the vehicle has been delivered by the dealer to a buyer on the date specified therein. The dealer is obliged under rule 36 of the Motor Vehicles Rules 1993, Orissa Motor Vehicles Rules 1993, to furnish the registering authority having jurisdiction in the locality the information in form 13 and form 14 in respect of the vehicle received in stock and sold by him during every month by 15th of the succeeding month. Further, the dealer shall furnish a copy of the sales certificate in form 21 prescribed in rule 47 of the Central Motor Vehicle Rules 89 to the registering authority of the concerned region where this vehicle intended to be registered. In form 13, which issued under rule 36(1), the trade certificate holder has to furnish the information in respect of the vehicle received in stock in category wise, whereas he has to furnish all the information in respect of vehicles sold in form 14 as per rule 36(1), and also give a certificate to the extent that the certify that the maximum number of vehicles covered under the trade certificate has never been exceeded at any point of time. After the vehicle is sold, the same has to be produced before the registering authority for registration. The registration has to be made as per the provisions contained in Odisha Motor Vehicles Taxation Act 1975. Section 3 deals with levy of tax, and Section 3A deals with levy of additional. The Section 4A thereof states that about the levy and payment of one-time tax, and Section 4B deals with the levy of payment of one-time tax on goods carriage. Section 5 thereof, which is relevant for the purpose of the case, envisages that notwithstanding the provisions contained in Section 3, 3A, and 4A, 4B, the tax at the annual rate specified under shall be paid in advance by the dealer in a motor vehicle in respect of vehicle in his possession in course of his business under the authorization of the trade certificate under Rule 89. Therefore, Section 5 is a charging section in respect of a trade certificate holder, which a dealer is liable to pay tax in respect of the vehicle in his possession in course of his business under the authorization of the trade certificate granted under the Rule 89. Therefore, there is no doubt that the dealer is liable to pay tax in advance in respect of vehicles in his possession in course of his business under the authorization of trade certificate granted under Rule 1989. The quantum of tax has also been fixed to be paid by the dealer under the said provision. If any tax is due not paid as provided under the Act, the same is recovered by a penalty under Section 13 of the Motor Vehicle Taxes, Odisha Motor Vehicle Taxation Act 1975. Recovery can be made under Section 14 of the said Act. More so, the procedure for recovery of tax and penalty has been provided under Schedule 2 as per the provisions contained in subsection 1 of Section 14 of the Odisha Motor Vehicle Taxation Act 1975. The tax recovery officer may also seek assistance from the officer in charge nearest police station for recovery of such tax penalty in conformity of the provisions of law. The scheme of provisions discussed above clearly indicates that the tax at the annual rate shall be paid in advance by a dealer in motor vehicle in respect of the vehicle in his possession in course of his business. And as such, under the authorization of the trade certificate granted under Rule 1989. Admittedly, the dealers paying the tax as per the trade certificate issued by the registering authority against the maximum number of vehicles possessed at a given point of time, and the same has also been paid by way of advance tax. It is no doubt true that the circular dated 29/3/2016 issued by the opposite part note 2 to all RTOs, which is the epic center of the present conflict, is an interdepartmental correspondence. As to the object behind the issuance of sub-circular, it has been clearly indicated that while reviewing the motor vehicle collection of different RTOs, it was found that tax collected in advance from the dealers for the number of vehicles mentioned in their trade certificate was not in conformity of the total number of registration of vehicles made by the dealers. And as such, the RTOs are directed to collect the tax from the dealers on the basis of total number of vehicles possessed and registered during the entire year by the dealer. The provision contained in the Odisha Motor Vehicle Taxation Act 1975 in clear and unambiguous terms states that the tax at the annual rate specified therein shall be paid in advance by the dealer in motor vehicle in respect of vehicles in his possession in course of his business under the authorization of trade certificate granted under the rules 1989. The provision is very clear that the dealer is liable to pay tax in advance in respect of the vehicles which he is in possession in course of his business under the authorization of trade certificate. Unless the vehicle is possessed by a dealer, the same cannot be sold. Unless the vehicle is sold, the same cannot be registered. Therefore, the possession of vehicle by a dealer in course of his business and the sale thereof, consequential registration of a vehicle are
intrinsically
connected to each other. For the purpose of possession of the vehicle in the course of business, tax is being paid levied under Section 5 of the Odisha Motor Vehicle Taxation Act 1975. But the vehicle is sold, the information is given to the dealer in Form 21, and basing upon which the application is being made by the buyer in Form 20, so that the same can be registered by the registering authority. For the purpose of registration, tax is levied under Section 3A of the Odisha Motor Vehicle Taxation Act 1975, but the payment thereof has to be made on the basis of Section 4A, 4B of the Motor Vehicle Taxation Act 1995. The owner of a vehicle had to pay tax levied and unless the same is complied with, no registration can be made to vehicle purchased by him. So far as the dealer is concerned, the tax is levied under Section 5 of the Act and the vehicle in his possession in course of his business under the authorization of trade certificate. Now, it has to be considered the expression of vehicle in possession in course of his business used in Section 5 of the Motor Vehicle Taxation, Odisha Motor Vehicle Taxation Act 1975. In Gurchan Singh versus Kamla Singh, 1976, SCC 152, the Apex Court held that deprivation correctly understood means the effective physical control and occupation. Word possession is sometimes used inaccurately as synonyms with the right to possess. In Madanlal versus State such and such, the Apex Court held that the word possession means the legal right to possess, and possession need not be physical.
No need to read all the judgments.
My lord.
So let's move. Even that business, we don't need to read everything. Meaning of business is not necessary. We move to the operative portion now.
My lord.
So it's para 35.
35, my lord. Importing the various meaning held by the Apex Court in as discussed above, the expression used in Section 5 of the Odisha Motor Vehicle Act, that will be Taxation Act, my lord. Odisha Motor Vehicle Taxation Act 1975, to the extent that the vehicle in his possession in course of this has its wide implication. In course of transaction, which necessarily precede the pronouncement, procurement, possession and sale and registration of the vehicle is a continuity of business. Therefore, once the vehicle is in possession in course of the business of a dealer under the authorization of the trade certificate, at the end of 12 months, if it is ascertained that the dealer was in possession of vehicle in excess of the number indicated in the trade certificate for which no advance tax has been collected, in that case, the dealer is liable to pay the tax in consonance with the circular issued by the opposite parties. Needless to say that under the trade certificate, the dealer is obliged to retain the number of vehicles mentioned therein, not beyond that at any given point of time, but at the ipso facto cannot disentitle him to pay the tax in respect of the vehicles in his possession in course of business. In other words, the dealers possess the vehicle in course of business, he is liable to pay the tax in consonance with the circulars issued by the authority concerned. The expression in course of used in section 5 of the Act indicates that the dealer is liable to pay tax in respect of the vehicle in its possession in course of his business under the authorization of the trade certificate. Therefore, the law is well settled that the vehicle in possession in course of his business, which implies a period of during which the movement was in progress, but the postulate also an indicated relation under the authorization of trade certificate is liable to taxation under section 5 of the Act itself. Thereafter, some cases have been referred.
Para 43.
Then my lord, para 43, my lord.
Yes.
Applying the above principle to the context of the present context and looking at the previous contention under section 5 of the Odisha Motor Vehicle Taxation Act 1975 and giving a strict interpretation to the same, it can be safely construed that tax at the annual rate specified to be paid shall be paid in advance by a dealer in motor vehicles in respect of vehicles in his possession in course of his business under the authorization of trade certificate granted under Rule 89. Admittedly, the trade certificate issued on the basis of the solemn declaration made by the dealer to keep in possession the number of vehicles at a given point of time, and nowhere it has been indicated that without the possession of the vehicle, the same can be sold for the purpose of the registration. Therefore, at the end of 12 months, if it is found that the dealer has having remained in possession of number of even not exceeding the number of vehicle in his possession at the given point of time as per the trade certificate issued, then he is liable to pay tax as demanded by the authority concerned because such vehicles were in possession in course of his business. At the end of the year, considering the number of vehicles possessed by the dealer in course of his business which has been sold for registration, if the dealer has been called upon to pay the tax under section 5 of the Act, in that case, the taxing authority has not committed any illegality or irregularity because of the basis of the declaration made in the trade certificate to possess the number of vehicles as declared by the dealer. The advance tax has been received and ultimately on the basis of the possession of the in course of business, the same shall also be taxed. The number of at a given point of time on the basis of trade certificate for which tax has already been collected in advance. For the balance vehicle which were in possession of the in course of business, the dealer is liable to pay tax in consonance with the provision contained in section 5 of the Act itself. On the basis of the circular
dated submission. So basically, I think what is being said is, although you issued a certificate that this is what number of vehicles in stock does not exceed what is stated in the certificate, in respect of individual vehicles that you still have, you have to pay because you're in possession of such vehicle. That is the finding of the single judge.
Yes. But the Act says otherwise. The tax has to be paid in advance annually. If I have to pay the tax annually, the intent of the legislature was certainly not the maximum number. Then it should have been told. It has been written that the number of vehicles sold, he has to pay tax. When the tax has to be paid in advance, and the Rule 5 says he has to give a declaration that he has not exceeded the number of vehicles as per the trade certificate.
Ultimately, you're collecting all this from the customers, correct?
But it is a question of double taxation. It is going to be double taxed, my lord. Because the vehicle, once the vehicle is sold, he is paying tax. He is paying tax to the vehicle. He cannot take tax twice from a vehicle, my lord. It is for the vehicle, since the vehicle are remaining with the dealer for a certain period of time not being sold, for that period, he has to pay tax annually, that he has to give a declaration to the taxing authority that I will keep 50 vehicles per month. My vehicle will not exceed 50. And for 50 vehicles.
My vehicle not exceed 50. Let us take an example.
Malad.
You have manufactured 500 vehicles this month, right?
Manufacturer.
And then manufacturers, you have bookings of 500 vehicles, let us say, as a dealer.
Malad.
So that month you sell 500 vehicles. You say at any given point in time, I do not have a stock of more than 50. So you pay tax only in respect of 50.
Yes.
But you have actually sold 500.
But that is been taxed. When the vehicle is sold, he has to pay tax.
That's all which is being talked about here.
No, he said that entire whatever vehicle you have sold, you have to pay tax for that.
But whatever vehicle you have sold, you have to pay tax.
No, section 5 of some Lordship Mercy.
With permission of my senior, my lord. My lord, if my senior, just to assist him, my lord. My lord, the concept of trade certificate, my lord, there are two concepts, if I can say. My lord, one concept is trade certificates, another is registration. Now, these both concepts come from the fact that what is needed for a vehicle to ply on the road. So, my lord, if my lord sees page 51, it has been discussed that under section 39 of the main act, Central Act, it has been stated categorically that no vehicle shall ply on a public road unless it is registered. Correct. So that's the law.
Correct.
Now, there is an exception provided to it. The exception is that some vehicles can ply on the public road without registration if it has a trade certificate of a dealer or manufacturer as well. So your lordships are correct as manufacturer as well. Why, my lord? Let me just make myself clear, my lord.
Manufacturer will delete. Delete.
My lord, what was the concept? What is this needed? Is, my lord, as your lordship knows, if lordship wants to buy a vehicle tomorrow, my lord calls up a dealer and says, give me a test drive. Right, my lord? So a dealer cannot bring that vehicle out of his dealership on main public road and give any customer a test drive unless it is either registered or he has a trade certificate. Am I clear, my lord?
Correct.
Now, my lord, so there is no question of the fact that every vehicle which ultimately goes to the road has to be registered. So for registration tax and all that has to be paid. No question on that. There is no dispute on that. It is being extremely well managed in our state. It's done it at the point of dealership. Now, the only difficulty, my lord, is now when the purpose of trade certificate is to allow a dealer to ply a particular vehicle without registration on the road, he is not plying all the 500 vehicles that he has sold on the road, my lord. My lord, may kindly envisage this. So what happens, my lord? I might be a small dealer. I might have only a small dealership where I only have a space of keeping 3 vehicles. And out of the 3, I'm keeping those and giving those 3 vehicles for test rides, for showing it to the vehicles. So, my lord, what I do, depending on my capacity to hold, I apply the main crux is in advance. In advance for a year, I apply saying that because I don't need I cannot keep more than 3 vehicles. I am only getting a trade certificate for 3 vehicles. Now I keep a trade certificate, if your lordship knows, it comes as a temporary number. There's a yellow patch number which says TR something. TC. So I paste it on those vehicles. And now, my lord, if tomorrow one of the vehicles that are pasted, because my lord knows, my lord, one more clarification, TC is not connected to the chassis number and engine number. That is only a registration is done. So, my lord, today, let's say this vehicle with engine number X and chassis number Y, I have put a TC number. I have plied it on the road. Then a person buys it. So when he buys it, it gets connected to X chassis number Y. I take out the TC, temporary TC, which I've taken for three, and then paste it on another vehicle that I get. So that's why, my lord has where it is written that for one TC number, you cannot apply 2 vehicles. That will be an error on my part, on a dealer part. So, my lord, with one TC, I can only run 1 vehicle at a time. So, my lord, the purpose is, now in advance, I have to ask. That is the law, which your lordship has seen. So, in advance, if I'm asking, I decide for a year, how many vehicle am I keeping in my possession and how much can I not go beyond? So, at any point of time, if I've taken for 3 and I'm keeping in possession more than 3, I'm violating, my lord, my TC.
But if I'm keeping 3, and with this 3 in my possession, I sell, as your lordship says, maybe 30 vehicles in the year. But I have never applied more than 3 vehicles on the road. Now, my lord, another crux here is, my lord has seen, which my learned senior started off with, your lordship has seen the entire judgment. Nowhere has Rule 7 of the Odisha Motor Vehicle Taxation Rule has been discussed. My lord, that rule has although been quoted as page 49. My lord, may kindly have a glance. At page 49, if I think Lord should be, it is 49. My lord, has it as 49?
Yes.
At the bottom of the page, Rule 7. 49 or 50, my lord. I'm
50, my lord.
50,
Lord, see 50.
My lord sees 50.
Rule 7 is quoted, yes.
Yes, ma'am. Rule 7, my lord, may I quote?
Yeah.
The Rule 7 of Odisha Motor Vehicles Taxation Rules. My lord, as my senior was quoting, they have already the judgment only quotes the act. Now, rule says, for the vehicles in respect of which no tax or additional tax is payable under Section 8, the declaration may be filed in Form BB along with the document prescribed in the notification in which exemption of tax of the vehicle has been notified, provided that no such declaration shall be filed for or tax of a token granted in respect of the vehicle which is declared off-road. Now, my lord, the next proviso is important. Provided further that dealers or manufacturers paying tax or additional tax under Section 5, which is the trade certificate, shall submit the declaration in plain paper stating legibly therein category-wise make and model of the vehicle and maximum number thereof. My lord, may kindly note that. Maximum number thereof for which tax or additional tax is being paid, and certify that the maximum number has never been exceeded at any point of time during the previous quarters. Along with and invoices, dispatch note instead of registration certificate.
Occasion for you people to come to the court? What was happening? What made you come to the court?
Yes, my lord. What made us come to the court was, my lord, we were always taking trade certificates, maintaining whatever stock we had asked for the trade certificate. Whenever there was a surprise visit and they found more, they used to charge those dealers and they were paying. Suddenly, my lord, they came up with a notification, a circular saying, although a dealer has taken five trade certificates, but at the end they found, because we also give, my lord, declaration of how many vehicles we have sold, they at the end of the year found that we have sold maybe, let's say, 30. So their assumption was that these 30 vehicles have at some point of time been in your possession. Hence, you are entitled to pay 30. Trade certificate for 30. Now, sir, the only difficulty, my lord, was the three issues. Number one, if we do that, then as my learned senior said, the purpose of in advance tax becomes redundant, because then you don't take in advance. You take at the end of the year, you say how many you have sold. Along with registration, you charge trade certificate. That's number one. Because, my lord, it is practically impossible for somebody to always at the beginning of the year imagine how many he's going to sell. That's number one, my lord. Now, number two, my lord, the entire purpose of trade, as your lordship says, in this judgment, what my honorable single judge has done, my lord, although single judge has said that you pay for the entire thing, how much you have sold, but at no point of time you should exceed your trade certificate. So it is mutually exclusive, my lord. So, my lord, may kindly imagine this. Although they have said that at the beginning of the year, you say you have taken it for 3 vehicles, right? You shall never have more than 3 vehicles in your possession.
So, but how does it actually work? I'm not clear. So let's assume you have to pay 100 rupees for a TC. So you say, since in terms of my trade certificate, I mean, whatever trade requirement, I need only 3 TCs. So this you pay per quarter, is it?
No, my lord. I pay in advance for a year.
So 100 rupees, you pay 100 into 3, 300 rupees for the entire year.
Yes. That is how it was functioning. So anytime they used to do a surprise visit and find 4 in my possession, they used to penalize me, which was how it was. But it was never connected to the total sale
sold.
But anyway, when the vehicles are sold, at that point, a tax is paid.
Absolutely. That's why I said, my lord, registration is 100% being taken care of. There is absolutely no overlapping of registration with trade certificate. Now, my lord, to answer your question, just for the sake of discussion. Now, my lord, what has now happened is, as your lordship said, now buyers have, an additional charge of trade certificate for each vehicle is being charged when that is not the law.
No, what is in effect? What does it do? Another 100 rupees in real terms, what does it work out to?
My lord, what has now happened is that now, number one, they have asked for arrears as well. They said that all these past years.
No, but this clearly the single judge has said it's prospective. I just noticed that it said it's prospective.
My lord, prospective, but for that year as well. For that year when they asked.
Whatever. I'm saying since it is prospective, there's no stay by the division bench. Is there a stay?
There's a stay as in they have said that it will be only prospective. The division bench has clarified, your lordship.
But even the single judge has clarified it is only prospective. And you are anyway paying it for the last so many years now, because this is a 2017 judgment. So the last 5 years you are paying this.
My lord, as per the division
for every vehicle sold. So this is like a tax on every vehicle sold now.
It's a tax on tax.
Whether the vehicle is used for test drive or not.
For test drive or not, my lord.
That is presumed that it would have been used for TC, although it may actually not have been a TC.
It's never used, my lord. As your lordship knows, my lord, all the dealers, my lord, will try and use as limited vehicles as they can because it eats on to their profit.
Correct.
So they will like to use as less vehicles.
But you pass it on anyway, because ultimately the customer is the one who's paying for it. You are never, as a dealer, you are not
that
paying.
is not the intention of the legislation, my lord.
No, it is.
No, my lord.
The legislator knows that you're not paying out of your pocket. The legislator knows that you're going to pass it on to the customer.
That is a different.
Yes. That's the matter. Even if you succeed in this writ petition, you're not going to get that 100 rupees back.
No, it's not about getting it back. It's not about getting it back.
No, I'm saying it's ultimately like those, Mafatlal cases. You remember that? Unjust enrichment cases of the Supreme Court, which was decided in the early 90s. First time before the amendment to the Excise and Customs Act, this was a question. When you say that the tax was wrongly collected, will the refund be granted to you or should it be granted to the customer to whom you've passed on the incidents?
This tax dealer has paid.
No, dealer paid, but he's collected it when you put a bill and you collect it from the customer.
Your lordship can always put it at rest saying that
pays it from his own pocket.
My lord, that question your lordship can always put it at rest saying that there can be no refund either to this or that.
I'm just asking. Therefore, in practical terms, for the last 5 years, you've been collecting this tax.
Yes, my lord. No, my lord, because we had
through the dealer, through the customer.
We had to, my lord, because of the judgment. But although, as my learned senior said, my lord, it was never envisaged. The entire.
No, but in real terms, per vehicle, what is the incidence of tax? I want to know.
Your lordship. So to that, my lordship may first come from the trade certificate, section 39.
No. In terms of rupees, sir, how many rupees are you paying per vehicle?
That my lord, I'm just telling.
Is it 1 lakh rupees, 2 lakh rupees, 10 lakhs rupees per vehicle? What is it?
49 of the judgment. Running page 49.
So you give us, now answer the question. Is it 50 rupees? Is it 100 rupees? Is it 500 rupees? Is it 5 lakhs rupees per vehicle? What is the amount?
So Act provides there is a slab. But where the total number of vehicles does not exceed 10, then annual rate of tax is rupees 2,000.
2,000. Then, so you divide it by 10, how much is it worth?
No, 2,000 per motorcycle. It is total listed.
That's an annual fee, sir.
For each vehicle.
But ultimately, you will not going to pay that from your pocket, sir.
That is not the question, because when the legislation is clear about that, your lordship must first go to section 39, where it started, how the trade, what is the trade certificate and how it's to be kept. Your lordship must see.
You read that whole thing, sir. Don't again read the whole thing now. You make your arguments. We've read enough.
No, your lordship has to understand what is the purpose of section 39.
You are there to educate us, sir. No, you educate us.
Sir, your lordship. May I be given the permission to my lord?
Yeah, all permissions granted.
My lord.
But you don't keep on reading. You just explain to us what you're trying to argue.
Yes, my lord.
You're saying, I've already explained, if I have TCs in respect of 10 vehicles, I need to pay this advance tax only in respect of those 10 vehicles.
Yes.
And not in respect of every vehicle sold.
Yes.
This is
And
the argument.
The form also provided in Odisha Motive rule, he has to submit form that he has not exceeded any number of vehicles. That form I am showing that. Your Lordship is form 13 and 14 appended to Mala Rule 36.
Page 51, my lord, of your
Page
lordship.
51, that form has been.
Page 51.
Got it?
Yes.
Furnishing the information in respect of vehicle received in stock by the manufacturer or dealer. One, the dealer name, such and such. The details of the receipts on stock. The category is, my lord, serial number, date of receipt, date of unit received, date of invoice and date and remark. Then form 14 is the furnishing the information in respect of vehicles sold. The name and the address of purchaser, engine number, chassis number, registration mark allotted, and RTO to whom the endorsed for registration. He has to furnish this form with regard to trade certificate that he has not exceeded the number he has taken the trade certificate for. And rule, it has to be correspondingly read with rules 7 of the Odisha Motor Taxation Rules, my lord. The rule says he has to pay the tax for the maximum number of vehicle he has kept under the trade certificate. And he has to pay in advance. Then what is the meaning of advance means, my lord? I cannot imagine how much vehicle I am going to sell in a year. The legislature, the advance word has been put to say that he has.
You still have not answered our question.
My lord.
Are you going to end up paying per vehicle 300 rupees, 400 rupees, 500? How much more are you paying per vehicle because of this circular? Tell us that.
I mean the deal.
You should know who you are, sir.
Yes.
You don't know who you are.
That for two-wheeler it is 2,000 rupees, and for four-wheeler it is 5,000 rupees. But for motorcycle, where the total number of vehicle does not exceed 10, 2,000 rupees, where such total number exceeds 10, 2,000 plus 200 extra for each vehicle.
So what you would do is, you will say, as per my declaration, I am not going to keep more than 10 in my showroom, correct? You will give a declaration that in my showroom, I will not keep more than 10. I'm giving you an example. In respect of those 10, you will pay an advance tax, which is 2,000. Correct?
Yes.
So you have spent 2,000 in respect of those 10 vehicles. If they on surprise check, they find you have 12 vehicles, they will add 200 more per additional vehicle.
No, and they will take penalty, my lord, for 200%.
How much ever, sir?
This is not for that, my lord. If
I have not even finished my question, you have started answering. What are you answering?
I am saying trying
you don't want to know what the question is.
Now, what your lordship trying to say, I understood.
Already understood. I have not even completed my sentence. I have not even asked my question. You have understood already.
Your lordship is saying that if I keep more than 10 vehicles, then they have to come and collect 200 extra. That is not that. If, my lord, I keep...
You have not even understood the question, sir. I'm so sorry to say that.
My lord, your lord.
You're not allowing me to complete. You're not allowing me to complete. You're already assuming what I'm going to say. You already started answering.
Oh, your lordship, I'm sorry, your lordship.
What have you as a dealer got out of pocket only in respect of these 10 vehicles which are in your showroom? You've paid an advance tax, correct?
That is not with each dealer, my lord. Suppose I keep 50 vehicles. My vehicle, I sell more than 500 vehicles in a year. I keep 100 vehicles.
Sir, whatever, you have given a declaration that you keep 100, you will never exceed 100, correct?
I keep 100 vehicles.
Suppose and you're assuring the authority, at no point in time I will exceed 100 as far as the showroom is concerned. Yes. Basis, the authority is asking you pay an advance tax.
Yes.
Yes, collected advance tax.
Yes.
You spread that advance tax over these 100 vehicles. How much does it come to?
200 plus 200, 2000 plus 200.
My lord is probably saying that it's a nominal amount. That's what your lordship is.
From your point of view, it is only a nominal amount. Even this nominal amount, because when the vehicle is registered, you're not opening a person paying. The man who's taking the delivery of vehicle from the showroom, he's paying all the taxes you've listed out.
No, this is the dealer pays, my
on that question, if you're saying that trade certificate can also be collected, my lord may kindly note.
No, assuming you don't pass it on, how much is the real incidence? Because ultimately you're holding those vehicles in your possession in the showroom. You're paying how much for, if you've given a certificate for 10 vehicles, you're paying for, if it is motorcycle, what are you paying? 2,000 rupees.
Correct, my lord. But
if it is cars, you're paying 5,000.
Correct, my lord. But at the end, what they are saying, that if you have sold 300,
you're not to pay, sir. They have to get it in their kitty. What you will do is, yes, I've collected from the customer. Here is the money.
I cannot collect it from customer, my lord. That is the problem.
Anyway, that is entirely your lookout, sir. You're such a noble-hearted philanthropist,
sir,
retailer, that you don't pass on this.
Sir, with
every other retailer, pass every penny to the customer.
That is, we are not. That is not permissible under the Act.
No. Nobody prohibited you from collecting it from the customer.
That is not permissible, my lord.
There is no prohibition, sir. There is no prohibition. Please understand how the trade works. Nobody pays these taxes out of his own pocket. It is passed on to the customer. We've all purchased vehicles. We know what the dealer gives you in the. Does he not give you a complete listing of things you have to pay? He says this tax, that tax, every tax. No dealer pays. So don't make that mistake. So this is what they're trying to tackle. And from the taxing authority point of view, they would want to extract the maximum. That is the nature of the very...
Even if the statute doesn't permit.
No.
Even if the statute doesn't permit.
No. Statute permits collecting tax per vehicle, correct?
That's registration, man. That's registration. That, as I said, man, that has nothing to do with trade certificate. Trade certificate is only that's
no. I think they're drawing a presumption that every one of these vehicles had a potential to become a vehicle with a TC.
If I make, I do not think so, man. The one they are saying is that because you have sold it, at some point of time it is in your possession. So they are going by only the concept of those particular vehicles are in your possession. But what has been lost in all this is the purpose of trade certificate, which we are trying to impress on, my lord. The purpose of trade certificate.
Because Section 5 uses the words, those you pay tax in respect of vehicles in your possession.
Exactly, my lord.
Even if the manufacturer brings the vehicle, let's say in that morning, and by afternoon you've given delivery.
Yes.
Those 3 showroom vehicles are still in the showroom.
Yes.
You say in respect of this vehicle, which came temporarily into my possession, don't ask me to pay tax. I've already paid tax in respect of those 3 showrooms.
I agree, my lord. What we are saying is as per that, because, my lord, as I said, my lord, the source of trade certificate is drawn from Section 39, which says, why do you need a trade certificate? You only need a trade certificate to ply your vehicle on the road without registration. Otherwise, what would I have done, my lord, for a test ride vehicle as well, I would have registered it. And when I would have ultimately sold it, I would have sold it as a second-hand vehicle.
So maybe you will not ask for TCs anymore then?
No, my lord, but that's completely gone now because, my lord, may kindly understand. So that's one of our, if the assessment is at the end of the year, you look at the sale figure and ask me for that, then don't ask me for in advance.
No, so don't ask for TCs at all then. Then the problem is solved.
No, but then also they will ask. No, that will not solve.
Have 3 in a showroom with some registration plates.
Your lordship may see
the entire loss, my lord, because those will go as second vehicles. As your lordship knows, that will go as second-hand vehicles. Number 1. Number 2, my lord. Number 2, more importantly, even if I don't get for TC, as it fell from your lordship, if tomorrow, my lord, as a thing, I say I'll not give any TC, I'll show on these online brochures and all that. No, if that be so, at the end of the year, they will say you have sold 300 vehicles, pay for 300. That's the crux, my lord. Because now what they have done is from...
Let's see that circular which is being talked about.
Yes, ma'am.
Where is that circular?
Your lordship wanted to that TC purpose for TC. Your lordship may kindly see Rule 41 of the Central Monetary Rules, my lord. What purpose the TC is being used, my lord? May I read that, my lord? Those purpose. The purpose for which the motor vehicle with trade certificate may be used. the holder of a trade certificate shall not use any vehicle in public place under that certificate for any purpose other than the followings. A test by on behalf of the holder of a trade certificate during the course of or after completion of the construction or repair. That is with regard to the chassis, my lord. For the proceeding or returning from the weighbridge for and after weighment or to and from the place for which it is registration to the registration. That is with regard to bus and trucks, my lord. For reasonable trial, this is for four-wheelers. For a reasonable trial or demonstration for the benefit of a prospective purchaser for the proceeding to returning from the place where such person intends to keep it.
That's Article 46, my lord, of your lordship brief. It's quoted at your page 46.
D, my lord. For the proceeding to returning from the premises of the dealer, of the purchaser or any other dealer for the purpose of delivery. For the proceeding to returning for workshop with objective of fitting a body to the vehicle or painting or repairing, etc. The F, for proceeding and returning from airport, railway station, wharf or after being transported. For proceeding or returning to an exhibition of motor vehicles to any place at which the vehicle is to be or has to be offered for sale. But and H is for only financiers, my lord. For removing the vehicles after it has been kept possession or on behalf of the financier due to any default on the part of the other party under the provisions of the agreement of hire purchase, lease or hypothecation. For this purpose only, my lord, the trade certificate is issued. And the trade certificate cannot be used beyond these purposes only.
Where is that tariff?
It's 76, my lord, or 74, my lord.
No, 74 of?
No, page 76. Annexure 2.
That circular?
Yes, the impugned circular. Your lordship has it?
Yeah, circular. Where is that circular?
My lord, it's page 76, annexure 2.
My
lord has it?
Yes.
Yes. May I read it, my lord? It's a circular dated 29/3/2016. It's from the Transport Commissioner, my lord, to all RTOs, Regional Transport Officers. So it is observed that there is a huge leakage of MV revenue at dealer manufacturer point while collecting tax for vehicle in their possession. As per Rule 35 of OMVR 1989, an application for grant or renewal of trades, shall I continue, man?
Yes.
Shall be made in Form 16, accompanied by appropriate fee as specified in Rule 81 by the dealer manufacturer. Separate application shall be made for each class of vehicle as per Rule 34 of CMV rules. On receipt of application from the dealers, the grant renewal of trade certificate is issued under Rule 35 of CMVR 1989 by the registering authority to the dealer manufacturers. Accordingly, under Rule 36 of OMV Rules 1993, the manufacturer dealer shall furnish to the registering authority having jurisdiction in the locality with the information in Form 13 and 14 that your lordship has seen in respect of the vehicles received in stock and sold by him during every month by 15th of the succeeding month. The manufacturer dealer should furnish the copy of the certificate in Form 21 prescribed under Rule 47 of CMV rules to the registering authority and the concerned region when the vehicle is intended to be registered. All the vehicles or manufacturers are bound to submit monthly returns in Forms 13 and 14 under Rule 36 of OMV 1993. A certificate in Form 14 are being furnished to the registering authority that the maximum number of vehicles covered under the trade certificate has never been exceeded at any point of time. This needs to be obtained from each dealer manufacturer surreptitiously. Section 5 of OMVT Act 1975 entails that notwithstanding the provision contained in Section 3, 3A, 4, 4A, and 4B, a tax at the annual rate specified below shall be paid in advance by a manufacturer or dealer in motor vehicle in respect of the vehicles in his possession in the course of his business. As such, manufacturer or dealer under the authorization of trade certificate granted under motor vehicle rules.
while reviewing the MV revenue collection of different RTOs, it is found that tax are being collected in advance for the dealers for the number of vehicles mentioned in their trade certificate, which is not in conformity with the total number of registration.
Just come to rule 26 of the Orissa rules.
Well, rule
26.
26.
This PC that you're talking of is in terms of Form 7, correct? Or is it different?
My lord?
This PC that they're talking of.
That has been now done away with, my lord. That, my lord, when a vehicle is sold, if the 7 days period is given as per Rule 47, if he wants to register it somewhere else, then he has to obtain a TC, temporary registration, that is valid for 1 month.
No. What you people are getting TC is what? Under which rule?
With the trade certificate, my lord, we are getting it as at Rule 7, my lord.
Rule 7.
Of the taxation rules. And
Orissa Motor Vehicle Taxation Rule 1976, my lord.
And the Taxation Act, Section 5. Well, all has been quoted, my lord.
No, we have it in the end.
Page 14.
So where is that schedule of fees attached to that?
That's a Section 5, my lord.
Section 5, my lord.
Of Motor Vehicle Taxation Act.
See, in real terms, what does it work out to people? Because in addition to this, when every motorcycle is sold, this 2,000 will be collected. No, per vehicle something 200 will be collected, I think.
2,000 rupees collected.
No, sir. For every vehicle, see, when it is sold, for every vehicle, only 200 for each vehicle.
For trade certificate.
Presume every vehicle sold to be in excess of this, and they collect another 200 rupees for that vehicle. That's it.
No, my lord. They can't collect the entire, my lord.
What is an entire? There's no entire, sir. Just read this.
Sir, I'll give a demand note. The demand, your lordship can.
You give whatever, sir. We are trying to understand the language of this.
My lord, may kindly see page 76. We have given a copy of the demand notice.
Right. Let's see that.
Page 76. Sorry. 78.
Because this circular which you read only says that since the number of vehicles sold is far in excess of this vehicles declared for the purposes of trade certificate.
The 200 will be happy, man. If they charge
no, that is how they will charge, sir. Because whatever is in excess.
But they are charging.
They will presume. No. It is B will get attracted. Where such total number exceeds 10. 1B only is attracted, sir. 5.
My lord, may kindly have my lord, I've given, there's an annexure of the demand notice where they have done a calculation. My lord, may kindly have it.
That is 200 for each vehicle.
That's what.
Yes.
So ultimately for that every excess vehicle in excess of the declaration in that for the purposes of trade certificate, let's say for the declaration he has given 10 vehicles. If he has sold 50 vehicles, for the 11th to the 50th vehicle, you will charge 200 rupees per vehicle.
Each vehicle.
Per each vehicle. He's trying to say you will charge 2,000 per vehicle.
No, 2,200.
No, Miller.
Not per vehicle, sir. Please.
Sir, I'll give the demand notices.
No,
Let them file an affidavit to that effect.
Yes.
Let them file an affidavit to that effect.
Yes. So
they are only that they are charging only 200 for the extra vehicle.
So there are only 200, 500, 1,000.
Yeah, lordship, let them file an affidavit to that effect.
It has to be only that.
My lord, there is a component which my learned senior is correct. My lord, may kindly have a glance to the demand. It will be clear, my lord. Just immediately it will be clear.
Where is that demand?
Let him file an affidavit.
My lord, let them file. Learned senior is saying is correct.
Let him file an affidavit. It will
close. First of all, let us see what is understood. What have you understood?
But the sole question, my lord, here, the obtaining a trade certificate is a condition precedent to keep a unregistered vehicle by the dealer. Here, my lord, there is a completely bar to keep or to possess a unregistered vehicle under section 39 of the Motor Vehicles Act, subject to condition that they have to fulfill the rules provided by the central government. That rules 33. Oh, Lordship may kind have a glance rule 33 of the central motor vehicle rules. That has been quoted, my lord. Rule provides, my lord. May I read my rule 33. Condition for exemption from registration. My lord, here all the vehicles is registered in the name of the registered owner. My lord, here is a condition which exempt the registration of a motor vehicle on the possession of the dealer. My lord, rule 33. For the purpose of proviso to section 39, a motor vehicle in possession of a dealer shall be exempted from necessity of registration, subject to condition that he obtains a trade certificate from the registering authority.
You're starting in beginning of the beginning. We are in chapter 7. You've gone back to briefs.
No,
anyway, we'll listen to you.
Why I am submitting, my lord?
All right.
So it is a condition precedent to obtain a trade certificate to keep the unregistered vehicle. My lord, the dealer, what happened? My lord, dealer obtained 20 trade certificate for keeping 20 vehicles. My lord, thereafter, it is found they have sold hundreds of vehicles without any trade certificate.
Why should they get trade certificate, sir? They'll get trade certificate in respect to the vehicles which they need to use for demonstration purpose.
For
every vehicle they're not going to be demonstrating.
That is not the intention of the legislature. Well, Lordship may kindly see the section 39 of the Act. Lord, here it may not be required for a test drive. A person not required a test drive, but he purchased the vehicle. But it is here. It is important is possession of unregistered vehicle.
Then why go through the charade of trade certificate then? No need for trade certificate.
Yes, my lord,
if mere possession of vehicle is enough to attract a tax, then you say irrespective of number of vehicles in the showroom, you pay so much per vehicle.
Yes,
be done with it.
Exactly. Yes, my lord. It is their possession. They have to pay the tax.
So why have this whole description of what is a trade certificate? No need. If every vehicle manufactured is going to be sold, then you simply say for every manufactured vehicle which comes to the possession of the dealer, he has to pay so much per vehicle. That's enough.
Taxation governs under the Odisha Vehicle Taxation Act. Here the Central Motor Vehicle Rules provides, Act provides, unless they obtain the trade certificate, they cannot keep the unregistered vehicle, dealer.
All right, sir.
Yes,
so, till they are registered, they will not keep possession.
Yes, my lord.
Not for possession, they will not sell.
My lord.
They cannot sell.
Yes.
Unless it is registered, only a vehicle that is sold will be registered, correct?
Yes.
Why have an additional tax just for possessing?
So, for possession, 5 provides, my lord, the tax in respect of vehicles under the possession of a dealer. Very nominal tax, my lord, at the rate.
Forget that nominal part of it, sir.
My lord.
You are now jumping now.
Lord, that section 5 provides, my lord.
It's a new information to us, sir. The last 1 hour, we've been hearing only this. Don't tell us section 5 provides. We have gone far beyond all that. We want to understand what is the purport of section 5. We come back to the same question we were asking you when we asked 10 minutes ago. Are you going to charge this 200 for every additional vehicle, or as he's contending, you're charging 2,000 per vehicle?
Any additional vehicle, 200 we are charging. Now it has been amended. Now it has been 500.
He's telling about trade certificate, not trade tax.
Now it is 200.
Trade fee.
Tax is 200 and the fees is 500 under the CMB rule.
To file an affidavit.
But for every additional vehicle under the possession of the dealer, we have collected 200 for each additional vehicle.
No, but their apprehension is you're asking them to pay again another 2,000 per vehicle.
No,
is that right?
No, that is my lord, not.
Let him file an affidavit, my lord.
Yes.
What is where is the demand letter? Show us the demand letter.
78.
78, man.
They are demanding 35 lakhs, 29,000, 2,950, 3 lakhs, 52,950 for
All
1,000.
unreadable. I don't know where you are able to read. I read.
It's
It's completely unreadable.
I'll file a type copy if your lordship. But at the bottom of the, if it's not legible, my lord, I'll file a.
Number 3,26,500. Next page, just come to this, page 79. In respect of 1,306 vehicles at 500 per vehicle. So they are charging, they're indicating what is per vehicle, sir.
This is trade certificate, not tax. This is only trade certificate. Your lordship may see.
No, this is the excess that they're charging you, sir.
Excess for trade certificate, again excess for section 5 they are charging.
There are two things, my lord.
Two
There's
things,
a
my lord.
TC tax, there's a TC fees. That's how it has been.
Now he is saying about the TC fees. That is 500, which were 200 earlier. Now it has become 500. Now the tax component he is not telling.
No, where is the demand for that?
If your lordship can be able to see this. My lord, this is if your lordship finds this more legible, my lord. I'm sorry, my lord. I apologize for this. This is a demand notice which they had given us, my lord. At the bottom, your lordship sees there are TC fees. My lord sees they have done 40 as per TC, which is what we had done it in advance for a year.
Also,
What is TC fees and what is TC tax? So tax is section 5.
We have been extremely confused with this, my lord. That's one of the grounds that we had challenged it for.
What is fees? What is tax? Why are you using two different terminologies? Have you come to page 77? Do you have page 77?
Yes.
What is fees and what is tax, sir?
Tax provided under the.
This is, I think, your sections. Page 77 is different from.
Yes,
not
ma'am,
the
that's
first
a
matter.
different. My lord, this is a batch of matters. So I had a legible copy, so I had given a legible copy. Consortium.
What is fees? What is tax?
But Odisha Motor Vehicle Taxation Act, Section 5 of the said act provides the tax in respect of possession of the vehicle by the dealer.
Then what is fees?
The TC fee provided under Rule 81 of the Central Motor Vehicle Rules to obtain the trade certificate in respect of each class of vehicle. That is why I am submitting. There is a complete bar. Lordship may bear me for the moment.
Sir, we are completely only bearing with you. We have not stopped you even for a minute. We want you, in fact, to give answers to our questions.
The line provides the subject to certain conditions, the unregistered vehicle can keep by a dealer subject to obtain a trade certificate. That section 39 read with Rule 34, 33 of the Central Motor Vehicle Rules. 33 of the Central Motor Vehicle Rules, so Lordship may find. Then how application will be made, how fee can be paid, that has been prescribed. So trade certificate fees has been prescribed under Rule 81 of the Central Motor Vehicle Rules.
So when you say rule 81.
81.
So if it is a four-wheeler, it will be 1,000 rupees plus 1,000 under the
state tax.
That is the fees, trade certificate fee.
So why have a trade certificate charge at all? If every vehicle manufactured has to be possessed, it will be driven into the showroom and then delivered to the customer, correct? Why do you have a concept of trade certificate at all then? Don't have that concept because anyway you're charging per vehicle. Whether he says, I will only keep 10 vehicles in my showroom or 20 vehicles in my showroom, you're saying we are not going to believe that. You're saying we will only go by how many vehicles you sold. Then why go through this entire process? All you have to say is if this is the number of vehicles sold, then for every vehicle, be done with it. Don't have this concept of trade certificate at all.
Well, that is the rule is there, my lord.
If the rule is there, then you follow the rule.
Yes.
You're understanding the rule by saying, let the rule be there. I am still going to presume that every vehicle sold by you is a vehicle for which you should have got TC. What you're trying to say is
that is going on.
Every vehicle that you have sold, we will presume that you have a TC for that vehicle.
Yes.
Therefore, you should be paid this TC fee plus TC tax for every vehicle sold.
Lord, that is going.
Lord, that is why they have come to the court, sir.
Lord, what they did, they have obtained 20 trade certificates and keeping 200 vehicles.
Not keeping.
Yes.
You're making a mistake. They've sold 200 vehicles, sir.
No, Lord, unless they possess.
Exactly. If this is your theory,
yes,
then don't have the TC concept at all then.
Lord.
Because every vehicle sold, you're going to presume that it was stocked.
Yes. It is remain with them.
Even say if it remains for 5 seconds or 5 days or 5 months, you're going to say it with you.
Lord, that restriction also is there.
What?
But they, a vehicle under a trade certificate can remain for 1 year.
No, but it can even remain for 5 minutes, sir.
Yes, madam.
Whether it remain for 5 minutes or 1 year, you have to treat it as possession.
Suppose in case a vehicle remain with them more than 1 year.
Let us say it remained only for 5 minutes. Let us take that example. You're still going to say, no, you should get a TC for this also, correct? Are you not going to say that?
This is the rule prepared by the central government and we are executing it.
No. So we are now looking at, if you are saying, don't ask me to defend this rule, it's a different question. You are called upon to say whether this is an arbitrary rule or a reasonable rule. So you've been paying since which last 5 years, all of you have been paying per vehicle sold.
Per vehicle, that's how they demand pursuant to this order, Melo.
No, they've been paying. Yeah, prospectively they've been paying. There's no stay. Stay is only for the already collected.
No, I mean, there was some demand, Melo, of the previous year that was stayed, as your lordship's in the writ appeal. But my lord, as my learned senior said, my lord, as it fell from my lord, may kindly imagine anybody can challenge our if my lord, if we quote it in a bill that for TC you give us 2,000 rupees, any customer can come and challenge because TC is not supposed to be paid by him because all the acts and sections that your lordship has seen is either a manufacturer or a dealer.
Correct.
And in advance. Now, my lord, may kindly envisage, as your lordship has been putting questions to my senior, how does one do it? How do you give a purposive interpretation to the statute? You say in advance. So you are putting obligation on each dealer to declare in advance and say also give an undertaking that I'll never go beyond. Now, all that has become redundant because at the end of the day, you say...
now they're going on a presumption.
Exactly.
They're saying since you've sold so many vehicles,
at some point of time must have passed through your possession, which is, my lord...
which is true. But the thing is that...
which is absolutely true actually, but not
because of the wording of Section 5.
No, my lord. My lord may kindly have Section 5 as well.
Right.
But my lord may also see the reason for which my lord, that's where we go back to what was the purpose of trade certificates.
That's the entire purpose, my lord. Why is trade certificate, the concept of trade certificate provided?
See, vehicles in his possession in the course business.
Yes, my lord. But that's the section. My lord, may kindly turn over the page and see the rules. My lord, the entire point is the rule was completely overlooked, my lord. My lord, may kindly see rule 7, which says, which I read, but just turn over my lord, just the next page. My lord, may see rule 7. Rule 7 said, third proviso, section 5 shall submit the declaration in plain paper stating legibly in category wise make and model of vehicle and maximum number thereof for which tax is being paid, and certify the maximum number has never been exceeded at any point of time. Now, that this entire rule becomes redundant. We can never do it because whatever I do in this quarter, I will definitely cross over the next quarter. And my lord can also just have a glance just to let you at page 43. As I go back, my lord, the purpose of trade certificate was never to say that you are at some point of time it is your possession, so you pay. That was never the concept. The concept was to use through the trade certificate, you are allowed to ply the vehicles for those reasons which have been stated under 41, my lord. Not beyond that, which my learned said out. Not beyond that.
So the words under the authorization of trade certificate had to be read along with possession in the course.
My lord. And also, my lord, as your lordship saw, by keeping trade certificate empowers me to use those vehicles without registration for those particular purposes, not beyond it. As your lordship know, for checking, for test driving, for weighing it.
Also, this circular, how far can you, by a circular,
my lord, that was another
levy something that has to be done only under the acts? Can you do it by a circular? And that too by a letter.
Not even a circular, my lord. It's only a executive instruction.
When there is a specific act, specific rules, can you just by a letter say that now hereafter you will start charging like this?
I will reply to that. Not here the Transport Commissioner has issued circular to...
Not circular, it's only a letter. Just
a letter to guide the registering authority.
It's a letter, sir. It's like a letter. Just see, it's like a DO letter.
It's written letter number, man.
DO letter issued to the...
This is the letter. It's not a circular. It's not a notification.
Yes, but the internal communication between the...
So how can on this basis the entire taxation system change? On basis of such a letter?
And previous to this, it was exactly as we are contemplating. Everybody was taking, if at all, assuming the learned senior is correct that somebody took 20, but at some point of time he had 200. For that, law prescribes, you can go and penalize him.
The only complication these kind of cases is you will have to file affidavits to say you did not pass on the incidence of this to the customer. You cannot. 100% you collected it from the customer. You will never be able to file such a affidavit that you never passed it on.
Also, as your lordship said, all those complications, there are hundreds of cases, my lord. Because there's one association where I was led by a senior, because of which I was asking for time, my lord. And other some individual cases. So, my lord, there's all over the state, and suddenly it just sprouted up.
Right now, you are following whatever that circular or letter is.
Because they kept on demanding
from every customer, correct? The additional fee is being collected.
Not too sure, but if you are
become the new normal now.
I'll take instruction if you're collecting it. Because
It must be. It's no way you will be paying it from your own pocket.
That's also a prejudicial assumption. I'll take instruction.
Lordship's query, judgment, paragraph 46 that has been replied.
What?
That issue of circular by the
Just read it.
When I read paragraph 46, but the rule 177 of Odisha Motor Vehicle Rules clearly states that all officers of Odisha Motor Vehicles Department shall be subordinate to Commissioner and shall exercise the powers and perform the duties as assigned to them from time to time under the Act and rules and the notification issued thereunder. They shall carry out the instructions and the orders issued by the Commissioner from time to time. In exercise of such power, since the order in Annexure 2 dated 29.
Is it an order?
My lord.
Is it an order? First of all, what has been issued in Annexure 2, is it an order? And does it say it is an exercise of Rule 177?
Lordship may keep it some other day. My lord.
Oh, that of course.
My lord, I am unable to know, my lord, the matter is listed. No. My lord.
So this kind of argument should be made when the matter is called out. Not after 2 hours of hearing the matter.
But in association case, my lord, some interim order is part, my lord, what I recollect.
Same interim order, my lord, as I said to your lordship, only prospective and no. That is not listed before your lordship. Those are 3 other writ appeals and other writ appeals that we were informing you of.
No, it's here in this also.
Furnish a list of the appeals, my lord.
Though the appellant shall be liable to comply with circular prospectively from the date of the judgment, no recovery of arrears shall be made from the appellant till the disposal of the writ appeal. So it's been postponed to the date of the impugned judgment. So the impugned judgment is dated what?
My lord, impugned judgment is dated
18 May 2017.
Yes.
Correct. 18 May 2017. So 1 more year you got the benefit of. So from 2017 you've been paying 5 years now.
My lord, whether we are paying, whether we have
no, paying meaning whoever is paying. I mean, the government is getting it.
Yes, the government is getting. That's the
yes,
appropriate way to say it.
So you file affidavits whether you passed it on or not.
I'll have to take instruction with regard to that, madam. You
say the court would like the
yes, my lord. Yes, certainly, my lord.
State to file an affidavit indicating clearly whether, pursuant to the impugned circular dated 29th March 2016, impugned letter, dated 29th March 2016, letter / instruction of the Transport Commissioner. What is being charged per vehicle sold is the additional fee in terms of Section 5 of the Orissa Motor Vehicles Taxation Act 1975. Question mark. The court will also like each of the, on behalf of the, an affidavit to be filed on behalf of the appellants. Affidavits to be filed on behalf of the appellants. I think we'll have one representative affidavit in that by the association, is it?
My lord.
Okay. An affidavit to be filed on behalf of the appellants, whether the additional incidence of trade certificate tax (TC tax) in terms of Section 5 of the OMVT and TC fees in terms of Rule 81 of the Central Motor Vehicle Rules 1989 has been passed on to the customer and has in fact been paid by the customer. Both sets of affidavits be filed after exchange with after a copy is being served on the other side before the next date. Interim order to continue. List on. December 5th.
We will also furnish the list of other appeals.
All right. Because we also have to be practical. in these kind of cases. Otherwise, the real issue will never be addressed. All right, we'll continue after lunch.
If I have to 49 and item 51,
list item number 50.
Permission to withdraw. Counsel, the appellant seeks leave to withdraw the present appeal.
Item number 52.
None appeals dismissed.
Item number 53.
53, my lord, may I praise your lordship. Item 53, my lord. I'm appearing in missing, my lord. May I praise your lordship?
Yes, please.
My lord, here the judgment under
Annexure 2 starts from page 58. Here, my lord, I am the purchaser of a land, general cash category. I have purchased the land from a scheduled caste community person, my lord. After the obtaining permission under section 22 of the OLR Act, my lord. Here, my lord, the performer, the respondent number 5, person, my lord. He applied for permission under section 2 of the Odisha Land Reform Act, my lord, before the revenue officer for sale of the scheduled property, my lord. Initially, 2004, he applied. Thereafter, he filed an application that was dropped, my lord. In the year 2005, he filed another application intending to sell the land in my favor, my lord, in favor of the appellant. Here, the permission was given after inviting proclamation. Permission was given. The land was sold, and I applied for mutation. That was allowed, and we have completed the construction, my lord. Here, the respondent number 1 challenged the order of the permission granted by the revenue officer under section 22 on the ground that since I am a scheduled caste person, I was supposed to and interested to purchase the land. Notice should have issued to me, and his appeal was rejected, my lord. Therefore, he preferred a revision. That revision was rejected, and he have filed the writ application. I was the opposite party number 1 in the writ application, my lord. The Honorable Single Judge, my lord, paragraph 7 at page 60, my lord. Sorry, my lord, page 65. My lord, place, my lord.
So all that has happened is the revisional authority has confirmed the appellate authority's order directing the sub-collector to re-examine the matter.
Yes, and the honorable.
So how are you agreed by this?
My lord, here this honorable court has directed, and a single judge has directed to appear before the revenue officer for re-adjudication of the issue, my lord.
So how are you aggrieved?
My lord, in my favor, my lord, the sale deed was executed, my lord.
That's all right.
So my some respective summons, there was no illegal infirmity, and all the procedures was followed, including inviting of proclamation before the revenue officer, my lord. This honorable single judge held that the procedure has not been followed prior to granting of permission, my lord.
Correct. Anyway, all your contents are left open, sir, for consideration.
I'm also the said proceeding is not over, still pending, my lord.
It's all right. We can make it time bound. Right. So the challenge in the present petition is to an order dated 20 July 2017, passed by the single judge, disposing of writ petition civil 10313 of 2007, filed by respondent number 1, in which an order dated 18th August 2005 passed by the sub-collector Bhadrak in OLR Appeal number 2 of 2006 and an order dated 23rd June 2007. Passed by the Collector Bhadrak in OLR revision case number 1 of 2006 were challenged. Without having heard learned counsel for the appellant and having perused the impugned order of the learned single judge, the court is of the view that it does not call for interference. Stop. It is seen that the single judge was of the view that while considering an application for permission under Section 22 of the Orissa Land Reforms Act, open quotation, there should have been a proper inquiry in the locality, particularly looking to the existence of the claim of a person belonging to the same caste, already there in the first round of litigation involving the same property before the same authority. Unquote. The learned single judge was of the view that the appellate authority, instead of dismissing the appeal, should have stopped his hand and left the matter to be decided by the sub-collector. Accordingly, the learned single judge has restored OLR case number 109 of 2005 before the sub-collector, leaving it open to all the parties to raise their respective contentions. It has been clarified that the sale transaction that has taken place in the meanwhile shall abide by the outcome of the proceedings under Section 22 of the OLR Act. The court is unable to find any error in the impugned order of the learned single judge that caused for interference. Nevertheless, it is in view of the submission of learned counsel for the appellant that the proceedings before the sub-collector have not progressed on account of the pendency of the present writ petition. Writ appeal, it is directed that the parties will appear before the sub-collector for directions, where the case will be listed for directions on 28th November 2020. And the sub-collector is requested to dispose of the matter in accordance with law after hearing the parties within a period of 3 months thereafter. The writ appeal is disposed of in the above terms.
Supplementary list item 54. 54.
Item 54, ma'am.
Item 54.
Yes, ma'am. Here the case, the matter concerns a lease granted under Mines and Minerals Development Act and the schedule area transfer of immovable property, that is called Regulation 2. The petitioner OMC, the appellant OMC was granted a lease in the year 1970, and in the year 2002, 3 of the respondents have come up and filed a case that this is the land belong to them, and this is a scheduled area. This area belongs to scheduled area notified, and the land could not have been transferred. And accordingly, the sub-collector as well as the appellate authority collector has held that this is a.
So this is a 227 case.
Yes, my lord. This
was an appeal maintainable.
My lord, this is 227 petition. However,
no, even the order says it's under 227. Come to the first impugned order, 24 July 2017.
Yes, my lord.
So since the impugned orders obviously passed under exercise of the jurisdiction of the learned single judge and Article 227 of the Constitution, the present writ appeal is not maintainable, leaving it open to the appellant to seek other appropriate remedies in accordance with law. The appeal is disposed of.
Item 55.
None appeals dismissed.
Supplementary list fresh admission item 56.
the delay is condoned. Admit the LCR be requisitioned. Paper books be prepared within 8 weeks of receipt of the LCR and be supplied to counsel of the parties. The Orissa High Court Legal Services Committee secretary will assign a lawyer. A complete set of the papers be handed over to the secretary OHC LSE, will in turn hand it over to a counsel of not less than 10 years experience to appear for the appellant. On the next date, the assigned counsel's name will be shown in the cause list. He will get in touch with the appellant in jail for instructions. List on 31st January.
Item 57 to 60.
Same.
Item 57 to 60, sir.
Same orders and same date.
60,
Delay
item 60,
condoned
22 days delay.
Yeah, all delay condoned.
Supplementary list item 61.
61. Yes.
Item number 61.
None appears to see some on this issue.
Item number 62.
May I please your lordship, my lord? My lord, I am VC, my lord. May I please your lordship, my lord?
Yes, please.
Matter relates to restoration of the case, my lord. The case was dismissed for default on 11/5/2015, my lord.
What is the matter for?
The
What's the delay in filing this application, sir?
my lord, delay was due to the negligence of the advocate clerk, my lord. Sorry.
No, not 2 years, sir. 985 days.
My lord.
That can't be condoned.
Your lordship may impose cost, my lord.
No. There's a delay of 985 days in filing this application for restoration. The explanation offered in the explanation in the application is not satisfactory at all. Consequently, the court is not inclined to condone the delay. The MC is accordingly dismissed. Consequently, CMP APL is dismissed. Yes. All right. Dismiss is withdrawn as no instruction.
Item number 63.
May it please, my lords.
Lord, I am for petitioners. Just a minute. Your lordship were pleased to issue notice to the opposite parties and passed interim order, my lord. And they have filed counter, my lord, yesterday and sought me copy, my lord. And my lord, I will also file rejoinder affidavit. And they have also filed an IA for vacation of stay.
So you answer that, sir. Kindly answer that.
My lord.
Kindly answer the application for vacation of stay.
The writ petition has been premised, my lords, on the broad allegation that the entire provisions of the OGLS Act and Rules, paragraph 1 of the writ petition, my lords. Paragraph 1, sub-para 1. It is pertinent to mention about 85 acres of Gochar land. Messrs. Aditya Birla. So, the entire process of de-reservation has been carried out by giving a complete go-by to the provisions as well as the intent and purpose of the OGLS Act and Rules framed thereunder in order to grant benefit to the corporate entity, and the general interest of the masses has been swept under the carpet. And then, my lords, he goes on to place the order sheets. But as my learned friend would, the AGA would, my lords, it's only a partial order sheet that has been placed. The entire process has been properly carried out, and only a partial order sheet has been annexed. Even in that order sheet, my lords, I'll take your lordship to the relevant provisions of the statute.
My lord, I have submitted the entire order sheet of both the reservations. Original order sheet, yes, original case record.
Lordship, may I have a look? My lords, I'll just place that provision of the statute. Yes. Section 3A, power to de-reserve land. The government may, by notification in the official gazette, authorize any officer not below the rank of a collector to act again. Lordship got the statute. To de-reserve any land which has been reserved under clause A of section 3 for any government land recorded as Gochar or any portion thereof. Any officer authorized under subsection 1 shall, subject to such conditions and limitations as may be prescribed, have the power to de-reserve any land referred to in the subsection or any portion thereof, if such officer is that such land or portion thereof, as the case may be, C, is in excess of the reasonable requirement for the purposes for which it was reserved.
What are you planning to do? Set up some solar panels?
My lord.
The entire rules have been...
What are you planning to do on the land? Set up solar panels.
We'll have a solar solar plant.
Solar plant.
Solar power plant. We'll have a solar power plant. Then, my lords, rule 4.
No, but from his point of view, if you set up the solar plant in the meanwhile, then his petition becomes infructuous.
My lords, yes.
In case you set up the solar plant in the meanwhile, his petition becomes infructuous. That is his concern. That's why he wants to stay.
What I was trying to draw your lordship's attention to, my lords, the caveat, the rules. Lordship may kindly have a glance at the rule, and this is directly covered by one of your lordship's own judgment, division bench judgment, my lords, here, and which relies on a Supreme Court judgment in 2011. Now, I'll just take your lordship to the rules.
No. What is the immediate urgency?
My lords,
this is kept for 1st December.
My lords, the planned halfway construction was...
what is the extent of construction? Let's show that. You have photographs?
Construction, my lords.
My lord,
show me the photographs.
Not begin. I have photographs last statement, my lord. I have given the photographs. It is on record, my lord.
May I be permitted to submit, my lord?
In the IA,
the case is also posted to 1st December, my lord. If within dim time the pleadings will be completed, then on that date, my lord, it can be disposed of finally, my lord.
200 workers are on site, my lords. All the entire machinery, entire raw materials are on site, my lords.
That's what. You show me the photographs.
We have to complete the project within a...
My lord, photographs I have given.
When did the project begin?
In the IA, my lords, up there. And this is a project which will be constructed in...
Where are the photographs? Not able to find you. When did this project begin? When did the project begin? When did you start construction?
Started.
I am appearing
recently
for opposite part number 5, but our responsibility is under the IDCO Act. We are constituted to get the land for industrial infrastructure, and in the process of after the land has been transferred, we have paid the total amount to the state government, and the total area we have given 60.20 acre land. And that is that we have given also 9/6/5/2022.
And that's only now, sir.
That
yes, sir. Only in May.
My lord,
June. Only in June you have given it.
We have given
June
it.
you have given.
We have given it. But one thing is that, my lord, if your lordship will find that in the DDJ proceeding, only just to assist your lordship and to my friend. My lord, under the Government Land Settlement Act, my lord, the procedure is there. If you have any objection, you come forward and make the objection. If your lordship will find this petition never made any objection in course of making the notice pursuant to the notice given for objection.
I will reply it. Please. I will reply it. Your lordship may kindly have a glance in the contents of the writ petition. The entire allegation is that there are 2 deregistration cases. The land allotted to this project proponent was earlier in other Kisam, and we have converted to Patita Kisam by initiation of a dereservation case under Section 3A of the OGLS Act. The allegation of the petitioners, who are supposedly the inhabitants of the local villager, they say that the Tahsildar has signally failed to follow the due procedure of law, and there is a clear violation of principles of natural justice in the dereservation cases, as a result of which the dereservation proceeding is vitiated in the eye of law. In order to substantiate our plea that there is the entire procedure has been duly followed, I have today produced the entire case record of the deregistration cases. Entire case record. There are 2 plots in 2 different moujas. There are 2 deregistration cases. I have produced the entire and also filed the counter affidavit. My responsible submission is that one thing I must want to draw your lordship's attention. These petitioners They were before the Tahsildar as a parties in the de-reservation case. That is most important. Your Lordship may kindly see, they were heard, they filed objections, they gave statements, everything was taken into consider. Rightly or wrongly, the authority has passed the order, the impugned order. I have the order of the collector, which was approved by the collector. I have annexed it in Annexure A/4 in my counter affidavit. That order of the collector is in exercise power under Section 3A of the OGLS Act, approving the proposal of the Tahsildar for de-reservation of the land. My respectful submission that you are a party before the concerned authority. You have suffered the order. You never challenged it in the appellate authority. Now you are coming before the Honorable Court by saying that the due procedure has not been followed. As your Lordship is taking view in any other cases, it is also a ground which can be urged before the appellate authority. So why the writ petition, it is in the nature of a PIL, will be entertained at the behest of the persons who are parties before the concerned authority, suffered the order, fought the case, then they filed their objections, everything they did before the, and ultimately the authority has passed the impugned order. The order, the collector.
Why did you not produce this order?
My lord, I have produced which order, my lord?
Collector's order.
But collector's orders, my lord, I have given paragraph that the collector is de-reserved pursuant to the two de-reservation cases, my lord. And I have also given the photographs, my lord, in IA number 1.
Sir, please answer the question. Why did you not produce these orders?
And my lord, order sheet I have produced, only collector's orders I have not produced, my lord.
That is the
main thing.
That is why I have taken the ground of suppression.
No, it is not.
That is why I have taken the
ground of suppression, sir.
Your Lordship, my kindly say, my lord, I have stated clearly.
I have stated that there is a suppression of
in paragraph
and only a part of the order sheet. That is why, to convince your Lordship that how we have maintained the procedure, and there is transparency in both twice the collector has written the file to comply certain queries, and those queries were duly complied with, and thereafter, after perhaps 1 year, the entire proceeding was continued, and ultimately the collector passed the order, which I have annexed as Annexure A/4. So these things praised by the petitioner, who are parties before the
The order of the collector is 8 December 2021.
Yes, my lord.
My lord.
Where have you mentioned this in your petition?
My lord, only I have mentioned in paragraph 17 that the collector Balangir, OP number 2, has reserved the Gochal land of such huge extent of villages Tendipali and Dungripali in an
So where have you mentioned about this order dated 8 December 2021?
He has not
mentioned. I have not mentioned because I have brought it through RTI, my lord. Whatever is given to me, my lord, I have annexed in both the de-reservation cases.
Where you have applied for RTI of this order, and whether it is rejected. So the evidence before this honorable.
My lord, and
this is a public order.
What they are telling that, my lord, my lord, we are simple innocent villagers, my lord. We are fighting for the community land, which was reserved at Gocha to be used for community purpose. And two solar plants in the neighboring villages have already been established, my lord.
My lord and friend is diverting the issue to
not issue.
You have suffered the order. You are fighting before the authority. You have suffered the order.
Not only that, my lords, page 20 and page 40 of the statutory requirement of 5%, the excess land, your lordship may kindly turn to page 20.
The RI report is exhibit C/4. I'm sorry.
Page 20, your lordship may kindly turn to the petition itself. Of the
land available in
he has not drawn your lordship's attention to this. Statutory prescription is 5% reservation, and what is left is, my lords, we have been 45.43 acres, of which we are in one village, we have been granted only 20 acres. So therefore, in excess 17% extra land is there, and in the other one at page 40, my lords, 71.92 acres extra is there, and of that we have been granted 13 point odd. My lords, percentage is already there extra, my lords, land for Gochar. So it's not as if that entire Gochar land is gone and statute has been violated.
Yes.
The rule says or.
My lord, I have filed 3 documents. First document, the collector's order. That is of December 2021. Then the corrected record of right pursuant to the order of the court. That is of January 2022. And then I have also filed the RI report for ready reference, which is also available in the original case records. RI has reported that surplus available there. So that is, yes, that is Annexure C/4.
Yeah.
They have not disclosed all these facts before the honorable court in the writ petition,
and this is a green project, my lords. Environmental Act clearance is not needed for this. This would rather help the environment.
Examine the matter before the NGT, he can raise that no EC has obtained or that. But so far as PIL is concerned, the entire focus is on the de-reservation process is bad in law. We have not followed the due procedure of law. That is why the collector has exceeded its jurisdiction or not acted within the jurisdiction conferred on it. While
This collector's order is appealable.
Yes, my lord.
It is appealable.
It is appealable before RDC. I can show your lordship.
But we are not formal parties to the proceeding.
You are a party. I can show the order.
Let me submit. If party, whatever is the legal procedure, I have to abide it by. But my lord, when public notice was there, if people have to have any objection to this de-reservation, you please come forward and file your objections. My lord, we the villagers, my lord, we filed objections. Even our depositions that it should not be.
So you can go and appeal, sir.
Yes,
order.
Yes, my lord.
You say 13839 of 2022. This is an application by opposite party number
7. Opposite party number 6, my lord.
Seeking vacation of the interim order passed by this court on 29th September 2022 to the effect that there should be no construction activity of any kind undertaken by opposite party number 6 on the land in question. Paragraph. Pursuant to the notice issued in the petition on 19th September 2022, a counter affidavit has been filed today by the state government, copy which has been handed over to counsel of the petitioner, as well as counsel appearing for opposite party number 6. Paragraph. The entire petition, projected as a public interest litigation at the behest of 9 villages of village Dungripani, PO Kurgaon, PS Saintala in district Balangir, was that the due law in terms of the Orissa Government Land Settlement Act 1962 (OGLS Act) was not followed while de-reserving land to be allotted by the government to opposite party number 6 for setting up of a solar plant. Full stop. The categorical averment was that the land in question was a Gochar land and the protests of the Dungripalli Gram Panchayat (GP) were ignored. Full stop. Copies of the depositions in the alienation case as submitted by the villagers were enclosed with the petition. Full stop. Paragraph. It now transpires that what the petitioners have produced with the petition is only part of the orders passed by the collector in the de-reservation cases. Full stop. It appears that at the conclusion of the hearing of the de-reservation cases, 2 orders were passed by the collector Balangir on 8th December 2021, copies of which orders, one pertaining to Mauza Dungripalli, the other to Mauza Tendlipalli, have been enclosed with the counter affidavit as annexures A4 series. Full stop. For some reason, although the petitioners were parties to the proceedings, there is no mention of these particular orders in the writ petition. All that is mentioned in para 17 is that the collector has de-reserved Gochar land of huge extent in both villages in an illegal and arbitrary manner, and has granted the same in favor of opposite party number 5, ITCO, for industrial purpose, which in turn has handed it over to opposite party number 6 for establishment of the solar plant. Paragraph. Also not mentioned in the writ petition is that it is not the entire Gochar land which has been taken over for de-reservation. Full stop. After the de-reservation exercise was completed and land was handed over to opposite party number 6, there was surplus Gochar land in both the Mozas, as is evident from the report of the Revenue Inspector, Gunsar, dated 14 September 2021, which has also been enclosed with the counter affidavit. This fact, namely that a certain portion of the Gochar land is still available to the villagers, was suppressed in the writ petition. Paragraph. Apart from the above, it is seen that the impugned order dated 8/12/2021 of the collector, in proceedings in which the petitioners themselves participated, is an appealable one. An appeal lies before the Revenue Divisional Commissioner against such order. Full stop. Since the petitioners have participated in proceedings, they would obviously be able to challenge the said impugned orders dated 8/12/2021 of the collector in an appeal before the RDC. Paragraph. For all of the aforementioned reasons, the court is not inclined to entertain the writ petition. The interim order is vacated. The writ petition is disposed of in the above terms, but no orders is to cause.
In delay in filing the appeal may be condoned, and we are agitating the
delay, if any, in filing the appeal will obviously any explanation for the delay in filing the appeal on account of the pendency of the writ petition will be taken into account by the RDC while dealing.
My lord, the filing on appeal is within 1 month from the impugned order of the my lord. That expired in January, my lord.
Supplementary list item 64.
My lord, I am for opinion number 5 for it.
Appearances may be noted.
Appearance may be.
Item number 64.
PL matter, Lord. Here, Lord, the petitioner, being a inhabitant of the village, has filed this application, challenging the inaction of the collector, not taking steps on the
Or at the petitioner's representation, annexure 1 series, shall be examined by the collector, and after notice the petitioner petitioners as well as opposite party number 5, and after giving them a hearing, the reasoned order should be passed not later than 3rd January 2023, and communicated to the parties within a week thereafter. The court clarifies it has not expressed any.
The party may be permanently, but the party may had letter. Petitioner be given this chance to.
Item 65.
65, as your lordship will find under item number 65, there are a batch of writ appeals. I'll take your lordship in seriatim. Lord, so far as these two batch of employees are there. One batch is contractual and other batch is we. Those who are appointed 1997 and they are in 2004-5 like that. There's no dispute about that. The dispute is both of them wanted regularization. In our batch of cases, judgment was passed. In these 3 matters, 561, 569, 583, their regularization judgment was also passed. Lord, I don't know, Lord, how these we against separate judgments for regularization, we can't be aggrieved against each other, man. We can't be aggrieved. So far as the first writ appeal is concerned, when I was interested with the matter, I found that this doesn't bear in merit because we can't be treated as persons aggrieved because this is a judgment in favor of these rest of the private respondents. We can't be persons aggrieved, man.
So 38 you are withdrawing.
30 has to be dismissed, man, because
all right. Writ appeal 38 of 2016. It is seen that the appellants have got relief in a separate batch of writ petitions involving themselves, and they cannot possibly be aggrieved by similar relief granted to another set of employees.
Yes.
Accordingly, the court declines to interfere at the instance of the present appellants with the impugned order of the single judge.
Right, Lord.
The appeal is accordingly dismissed.
Right. Rest of the 3 writ appeals, my lord, those the other batches, they are challenging judgment in my favor. The same thing has to follow, my lord, because they can't be
for the corporation. Lord, writ appeal number 561, that is what we have filed, my lord. Your lordship may pass the same order.
Yes. 561, 569, 583. Same order as the first one.
Now, State of Odisha's writ appeal have earlier been dismissed by your lordship. Lord, those orders are here.
741 that has been implemented.
741 cons for the appellant. State of Odisha states that the impugned order has already been implemented.
Rest is corporation's
your lordship. One just thing, Mr. Dhaw, one just thing. In the corporation's writ appeal, State of Odisha challenged the same judgment, and your lordship, the day before yesterday, your lordship has been pleased to dismiss it for non-prosecution. Now, Lord, corporation.
The ground of limitation, your lordship.
So this appeal is dismissed as infractious.
This my case may be dismissed as a bar by a limitation. 2 years, more than 2 years delay.
All right. The delay 56 and 57, there is a 58, 59, 60, 61, 62, 63. There's an inordinate delay in filing these appeals, which have not been properly explained. Accordingly, the MC number applications for condemnation of delay are dismissed. Consequently, the appeals are dismissed.
Appeal number 561, my lord, the judgment implemented. We have been implemented.
All right.
Yes, yes, yes.
All right. All right.
Supplementary 66.
May please, my lord. Sir, my lord, this is an appeal against the order passed by the Honorable Single Judge, where, my lord, in this case, the Odisha Public Commission has advertised under Annexure 4 to fill up the post of dental surgeon in Group A category, my lord. People, lordship will find from Annexure 4 what are the requirement need. Page 33, my lord, have a glance. Education qualification. First, we will lordship have a glance. Online application form will be available till 11/10/2018 by 11:59. Education qualification, my lord, this is mandatory requirement. A candidate must have purchased a bachelor in dental surgery, BDS or equivalent degree from a medical college or medical institution recognized by the Dental Council of India, and also have purchased a registration certificate under the Dentist Act 1948. This must be by 11/10/2018. And that has also been indicated. The lordship will find page 36, my lord. Page 36, my lord, have a glance. Clause 7, first. Only those candidates who possess the requisite qualification and within the prescribed age limit.
So this is 18 November 2021, more than almost a year old, this judgment. The impugned judgment of the single judge is almost 1 year old.
About, my lord, but
there is no stay granted by the division bench. What has happened to the directions issued by the learned single judge?
We have not implemented. Because
for 1 year, you have not implemented.
On the ground, it has been filed in time. As soon as the order has
Sir, in the Orissa High Court, there seems to be an unwritten rule that the minute you file a writ appeal,
my lord,
you don't have to do anything.
My lord, on my mention yesterday, it has been listed.
Very great, sir. That is very kind of you. Extremely kind of you.
No, my lord, we have not implemented.
It's a people give yourselves a stay.
No, my lord.
Why do you need, don't need two judges to sit and, you have yourself given a stay, sir.
No, my lord, because it has not been listed, otherwise we have.
No, not been listed means you have to implement, no?
Yes, that. My lord, may have a glance. What are the requirement is, my lord? Here, my lord, the mandatory requirement.
So there's no contempt file, nothing.
No contempt notice we have received. Here, my lord, your lordship will find only those. It has been mentioned in our advertisement. Only those candidates who possess the requisite qualification within the prescribed age limit by the closing date of receipt of the online application will be considered eligible. Thereafter, my lord, have a glance. Admission clause 9, subclause 4. Admission to examination will be purely provisional if on verification at any stage before or after the examination it is found that the candidate does not fulfill any of the eligibility condition, she or her candidate will be liable to rejection. Decision of the commission.
Provisional degrees, correct? Normally, provisional degrees are issued. Pending the final degree.
Yes, my lord. Now, my lord, what happened, my lordship, of then this is the requirement as per the advertisement. Your lordship will find from annexure page 31, annexure 2, this respondent, he has obtained the certificate much after the last date of submission of application form. Because on the application of in the advertisement, we have mentioned that 11/10/2018 the last date, but he had not produced the same because he has under annexure 2 on that the certificate has been issued on 11/7/2019. So, my lord, when he has filled up the application, he has not produced the same because at that time he has no requisite qualification, which is minimum requirement. And, my lord, he has filled up the form mentioning that he has fulfilled all the criteria and condition. So, my lord, as per the advertisement, we call them to appear in the examination. And when on verification, we called for verification, it is found that at that time he has no requisition, for which, my lord, we have rejected their application, even though we have allowed them to appear in the examination. Now, my lord, he challenged the same that he challenged this under Annex 8. He challenged because we have said that since you have not fulfilled the criteria, it has been cancelled. We challenged this, and the Honorable Single Judge, even though said that he has not fulfilled the required qualification, that will be available at page 11. I may permitted place. From the above pleading available on record, it is made clear that candidature of such candidates who had submitted their application through online, having not satisfied the requirement in terms of the advertisement, was rejected by the commission. Therefore, if the petitioner not satisfied the requirement of the advertisement, having no requisite qualification, he should not have been called upon to appear in the examination. Once the petitioner was called upon and allowed to appear in the examination, subsequent rejection of the candidature at the stage of document verification is absolutely misconceived one. So this is the ground.
Please read, continue, sir.
More so, under note 2 of clause 10 of the advertisement, the required certificates document to be produced, such a degree certificate, caste certificate, ODI pass certificate, discharge certificate, ex-serviceman and disability certificate of the PWD candidates indicating 0% disability must have been issued by the competent authority within the last date fixed for receipt of the online application. Undoubtedly, is one of the mandatory requirements prescribed in the advertisement that these documents are to be filled within the last date fixed
filed. Documents are to be filed, sir, not filled.
Sorry, filed within the last date fixed for receipt of the online application. But there was no mention with regard to production of compulsory housemanship certificate and medical registration certificate under the Dentist 948. Thereby, these documents may be required for verification of the documents as per the advertisement, but not mandatory required to be obtained before the last date of submission of online application. If that be so, opposite party number 2 could not have rejected the application on the ground that the petitioner does not possess the compulsory housemanship completion certificate and
so
medical
these two certificates, did he produce it subsequently?
Yes, my lord. When
he has produced, so it is not that he does not have these certificates.
No, my lord.
He only did not produce it before at the time of filing the application.
But he has to complete the housemanship at the time of, at least at the time of last date of admission, last date of submission of application form. The last date of submission application is 11/10/2018, but he has completed the certificate course on 11/7/2019, as will be revealed from Annex 2. That is much after that. So at that time, when he has filled up the form, he was not having the requisite qualification.
You just say notice.
My lord.
You accept notice.
I am for the respondent.
So how do you explain this, sir?
Yes, ma'am.
You completed your housemanship only in July 2019. The last date for applications was October 2018.
My lord, my first point is that this writ appeal filed in March after 1 year. Second thing, the contempt petition, my lord, my brother told already contempt petition filed. It was listed, but either delivered, they did not appear in that case. Contempt petition. So contempt is still pending before this court till date also, today also, because they have not acquired what is the cleverness, I do not know. And second thing, regarding housemanship completion, but there is mandatorily not required housemanship completion before 11/8. The submission of online application, nowhere it has been stated in their advertisement. And I am coming, the educational
submission of form is one thing, actual completion of the course is another. While the form may not be compulsorily requiring you to submit the certificate along with the application form, you have to complete the course, sir.
Yes, sir. We have completed the course.
When did you complete?
On 2018, petition completes BDS examination. 4/9/2018, the OPSC makes an advertisement call for the interview. Then,
so when did you complete your housemanship?
Housemanship, my lord, before Bhavas.
Give us the date of completion of housemanship.
Yes, my lord. I am giving this. Each housemanship I completed, my lord, on 5/6/19.
English to
5th June 2019.
Okay, 18 and 19, there's 1 year
19.
difference.
19.
19. What is the last date for submission of application forms?
That I want to say, my lord, that the application form, the required certificates I have submitted. And by the Annexure 10 of the writ application.
Sir, for applying for this particular post,
yes,
you have to have this housemanship completion certificate.
Not mandatorily, nowhere it has been stated in the advertisement.
What are you saying? Let's go to the advertisement.
Yes, ma'am. Nowhere in the
First, read the advertisement.
Yes, ma'am. Provided eligible being selected for those eligibility criteria are different, not the housemanship certificate. The eligibility criteria.
Yes, sir, certificate, please try and follow the question.
Yes.
Submission of certificate is one thing, completion of course is another.
Yes.
You may not have submitted your certificate.
Yes, ma'am.
But certainly you should have completed your course before that date, sir.
And before interview I have completed. But not
so before the date of application should complete.
Okay, madam. If I have committed some mistake.
Not mistake. Course itself was extending beyond that date was supposed to mistake.
It is not, I have to submit it is not nowhere it has mandatorily stated nowhere in the advertisement it is stated that provided that candidate be eligible for being selected the post of dental surgeon. If
where are you reading? Where are you reading?
In my written argument.
Page number.
I have written argument I have filed before the single judge from that if it is gist of the matter.
There must be some averment, sir. Without advertisement, you have filed a writ petition.
No. It is written. I am going from a written argument. A copy of the written argument filed.
Sir, in the advertisement, there must be a.
No,
Annexure 4 is the advertisement.
Advertisement or annexure?
Let's go to the advertisement. 1 minute, sir. Let's go to the advertisement.
Clause 3 of the advertisement.
1 minute, sir. Para 3 of the advertisement. Please read.
The candidate must have possessed a bachelor degree in dental surgery, BDS, or equivalent degree from medical college or medical
educational qualification. A candidate must have possessed a bachelor degree in dental surgeon, BDS, or equivalent degree from medical college or medical institute recognized by Dental Council of India. Eligibility, educational qualification, eligibility. Only those candidates who possess the requisite qualification and within the prescribed age limit, etc., by closing date of the receipt online application will be considered eligible. Here, my point is that if I am not eligible, suppose I to say for an argument.
No, 1 minute. Where is this housemanship?
Find from education qualification.
That is stated. My housemanship.
1 minute, sir. I'm asking him. You kindly.
Yes, it has been mentioned. Purchase a registration certificate and order the Dentist Act 1948. That clause 3 education qualification, subclause 2, it has been mentioned. Have purchased a registration certificate under the Dentist Act 1948. Have purchased required conversion certificate recognized Dental Council of India DCA in case of candidates having degree of University of Foreign. Here, my lord, the lordship will find unless he has completed housemanship, he will not get the registration certificate under the Dentist Act 1948. And she will find from Annexure 2, which he has produced, that he has completed the housemanship, got the certificate on 11/7/2019. And thereafter, my lord, he will get the certificate which is to be issued by the registration under the Dentist Act 1948. He is lack of that. And in spite of that, my lord, even though there is a stipulation that in case you will give any false information, your candidature can be rejected outrightly. Anyhow, subsequently,
no false information has been given. It is not appropriate to use the false information.
No. 1 minute. The completed his housemanship only on 11 July 2019.
Minor.
And in terms of what were you saying this?
Well, this is the certificate which has been issued, Annexure 2. Your lordship have a glance. He has page 31. My lord have a glance. Annexure 2.
One is the certificate being issued on a certain date.
Yes, my lord, that with the certificate. Annexure 2, my lord, may kindly have.
Period of 12 months is after the year.
Yes, this is to certify that Church has passed the final BDS.
2 sentences which will make it more clear. My lord, in clause 3 of the advertisement prescribes educational qualification. The 8 describes other eligibility condition where the recruitment of completing housemanship by cut-off date does not find place. By this cut-off date, housemanship is completed. There is nowhere it is mentioned.
No, you accept. We can dispose of the appeal today itself.
Yes. My second thing, if my candidate has to be rejected, it should be rejected at the inception page when I applied online. Before they should not call me for attending the written examination after scrutinizing my certificate. When total 29 of candidates completed written examination success, I among them also success. If written examination, even you got a chance at the initial stage, I should my candidates would have rejected what my brother said. They did not reject my candidate for the point of housemanship. Their only point is housemanship not completed before submission of the application, that is 11 August. Madam, I have to say that nowhere is prescribed. They buy before completion date, you have to submit. Suppose I have not
submit, sir. You have to be qualified. You're mistaking the two different requirements. By the date of the last date for submission of application, you must be qualified. You may submit a certificate later, but you should be qualified.
That has not been clear.
No, very clear. That is very clear in the advertisement that you must possess.
Okay.
It says must possess the registration certificate.
My lord, I agree. I agree, madam. Suppose I have not completed, I have not passed. Then my candidature should be rejected when?
There's no estoppel against this, sir. Please, there's no estoppel against this.
When other candidature has been rejected by...
There is no estoppel against this requirement, please.
When other candidature has been rejected by Annexure 10 of the writ application, then my case did not rejected at that point of time. When other my similar situated persons candidature has been rejected...
So these are all mandatory requirements. You cannot dilute this requirement.
Reject some candidates now, some candidates after, some candidates at the different stage.
On the date of submission of the application, you should have possessed this registration certificate, and that is the Dentist Act. Very clear.
Yes. Then
this advertisement makes it very clear.
Yes,
you must possess the certificate.
Then as per the advertisement, they should reject my application, my candidature before not.
That is why there is no estoppel against law. That is why the principle is no estoppel against law.
Then when I again completed. I am
go for different advertisement,
it's okay, but the government should
go for a different advertisement.
When I did not complete it, you should reject my application. You should not call me for the written examination.
Right.
Secondly, when written examination, I qualified. I did not follow up. I qualified. I am a doctor. I will serve for the people. When I qualify, you are telling that no. You call me for a virus test. For verification of the document. That is actually exact what is stated. Documents to be produced before verification as and when asked for. That means this housemanship certificate or other original hard copy, which I have submitted online copy, all the original copy, like matric certificate, other list, my list they have stated, matric certificate, etc. Certificate, housemanship, all should be submitted at the time of verification or physical verification. It is my third round. First, I applied. You did not reject my application. Secondly, you called for me to attend the interview. Not established. It's okay, madam. I am innocent. Then you are of the authority, government authority. They can I attended the written examination and I qualify. Not all. 29 incumbents qualify. A doctor. I am. And another point that this recruitment is not general. It is a special drive recruitment for ACST persons. It is a special drive recruitment for the ACST persons. It is not a general drive for other interview like this. So it is a special. This advertisement is a special drive only to appoint the ACST person. Mine did not reject at the inception when I applied. If I don't possess the certificate by the authority. Secondly, you allowed me to attend the written examination. I allowed. I did not fail. I qualified. Because I am talented, I qualify. Let us see greatly for the betterment of the society and being a benevolent of the government. I qualify. Then also you did not reject my application and call me that you come and attend the physical verification of the document. What documentation? All the documents are in original, like maternity certificate, dental certificate, all of the original hard copy. The soft copy I have submitted online. I should produce the hard copy. So when at the last stage, 11th stage, when I supported the hard copy, you raised the point that you did not complete the housemanship before 11. When? Minor on last after long together. The advertisement written examination 11-10-28. They rejected my application on bar of 11-10-2018. They are pointing and they rejected my candidature on 12 September 2019, just after 1 year. So I do not have possessed the requisite qualification. OPSC took time to verify this after to 1 year, and I should be harassed and punished for being a doctor. We service for the
my honest has not seen the advertisement. Otherwise,
it's all right. Let him finish. He's seen it. He has seen it. He's arguing. Yes.
If my not allow, I will file objection to this study.
No. We are hearing it finally, sir.
Yes.
That's why we heard you at length now.
My submission, my tender should, if rejected, it should be rejected at the time of initial.
To clarify that,
Only again written examination. When at the last stage you are calling me.
Clause 9 is very important.
No, why
have
is
every
clause
right
like this?
All right, sir, please.
Why the authorities, they did not think about that for a long year, 1 year. After 1 year, 10 October 2018 to my lord, 12 September 2019, 1 year too. Whether I only point that whether I possess house tenancy certificate or not, to inquire or to that as the authority, it is your duty to verify the certificate from the beginning.
All right. The challenge in the present appeal is to a judgment dated 18 November 2021, passed by the learned single judge. Only in one of them you have challenged, is it?
There are two applicants, two writ petition. We have filed two applications, 66, 67. Both are analyzed. Both have come.
All right, just put both writ appeals in writ petitions. Civil 18119 of 2019 and 18127 of 2019.
My lord, because in also it is stated in 6 of them, only those candidates who possess the requisite qualification and within the prescribed age limit by the closing date of receipt of the online application, what he's telling, of the application will be considered eligible.
Correct. So I'm glad you pointed that out.
Yes.
So that completes the answer. That's a complete answer to what you've been arguing.
Yes. My lord, when I applied and I'm ineligible, should I be informed after 1 year?
So you know you're ineligible, sir. Nobody needs to inform you anything. Once you know you're ineligible, that's not a matter.
My candidate should be rejected. No information. The authority should reject my candidature at that point of time.
All right.
Beginning.
Heard you, sir.
As per their condition, my lord.
Right. The second candidate also the same dates, is it?
Yes.
The second candidate, this second.
Yes, he was rejected and his application, that rejection has been enclosed.
The rejection made as per the suit of the authority, not as per the advertisement or as per the procedure or as per the due procedure of law or at the appropriate time. That is my submission.
Annexure 8 page 46.
On their suit will, whenever they desire, they will reject the candidate.
Annexure 8 page 46 is they were informed that their application has been rejected. Annexure 8. Both the original application are same and both name are fine place. Roll number are fine place.
And the decision they attach to their application is not applicable in our case. The decision of this honorable court, they have applied, they have attached, is not applicable.
Mandatory provision has not been complied with. We have also enclosed that under Annexure 4, page 94. Your Lordship judgment is there because at that point of time, that particular candidate could not pass ODI in time, subsequently passed, but Your Lordship under Annexure 4 has rejected, has not entertained the.
Another, I want to one line before Your Lordship. Pertinently at note 2, it has been mentioned that degree certificate, caste certificate, ODI test pass certificate, discharge certificate, excellent disability certificate have been issued by the competent authority within last date fixed for receipt of online application. No housemanship is stated. So many certificates stated, but no housemanship. How you can reject my candidate on that ground? Here is note 2. It has been mentioned clear that degree certificate, caste certificate, ODI test pass certificate, discharge certificate from ex-serviceman, disability certificate must have been issued by the competent authority within the last date fixed for receipt of online, that is 11/8/2018. Housemanship has not been stated. So my submission, the authority have not explicitly or mandatory stated in their advertisement that it should be submitted at that point of time. It is not.
So you should possess, sir. You may not submit, but you should possess. The advertisement is so clear. Have possessed a registration certificate under Dentist Act. You must at least have it with you. You may get it. You may produce it later, but you can't get it later. There's a difference between the two.
I get it before the interview I faced.
You have possessed the language. Just come to educational qualification. A candidate must have possessed.
Yes, Miller.
To have possessed means on the date you're making this application, you must have in your hand the dentist registration certificate.
Yes.
That is what the advertisement says.
Then,
whether you produced it later, 1 year later, 2 years later is different.
I agree, Miller.
You must have it in your hand when you fill the application.
Miller, what is the responsibility of the OPSC?
No. What is your responsibility? Did you have it in your hand when you wrote this application?
No, why you call for me in written agreement?
That's your only point, no? That is your only point.
Not only.
Answer.
What else?
Country.
What else?
The ground they are on their
My lord, my honor.
We can't dictate the order now. Because the minute we start dictating, both of you start arguing.
They're more on their sweet will, the authority having many people. I am a single individual. They can reject. First round, did not reject. Second, call for the written, I qualified, did not reject. Then calling for the vice in the hard copy, original copy. That point I will reject me after 1 year. It is not, never looks like proper or appropriate. That's why, and I am a doctor. I will solve for the community, for the entire society. I am qualified, duly qualified, not qualified written. If I would have not qualified by the written examination, if I would have not physical verification, you stated that as and when required. You submit that hard copy. Verification, the word is as and when required. So how it is mandatory? So as and when required, I submitted at the time of verification.
Clause 9.
And on that point, you will reject my candidature. On that point, reject my candidature.
All right. 66, 67 appeals are allowed. We'll pass the detailed order. The appeals are allowed. All right.
Supplementary list item 68.
There is no delay, my lord.
All right.
My lord, because I am a doctor, I want some little bit lenient view on this one. Because I am a doctor, I expect me. I am not an ordinary. I have not come here to.
You've done well, sir. You've done well.
Because I am a doctor, it is a special tribe for scheduled tribe, and I am a lower category.
Whatever say. Or education qualification, we can't have any compromise on this.
I am a doctor. I am a doctor. I have qualified before the interview. I have qualified.
Very good, sir. Very good.
Online line qualified.
All right.
Before attending the interview, I mean, they did not reject at that time. Or you will reject on your sweet will at the high was not at the beginning. First day, second round, third round, fourth round. They should not be allowed to act on their sweet will. They should act on the advertisement as per the law.
Same order.
Item number 69.
No, please. This is also, my lord, the writ appeal filed by the Odisha Public Service Commission. Here, my lord, this is the advertisement in the year 2015 for the post of assistant executive engineer, my lord. The petitioner the opposite party, the respondent, private respondent is not.
1 year delay file kale. Sabu kam again delay. But rejection be delay. Not in initial time. And all the delays, if will be allowed by the honorable court, this practice of unapproved practice.
If I hear more of you, I'll learn Odia now.
This vision, my lord.
Because my mother thing Odia. It will come sometime. It more that is all the things delayed. And it should be, if you wonder court will allow this will have a ill or wrong practice by them will continue. It is okay. Some responsibility. If my certificate not
within 2 months we will argue in Oriental.
You should reject my application. Coming written and when I got selected, not only reject. All these are not approved. Don't never look nice. Not approved, not as per the law, my lord. I am a simple, innocent man, a CST person, a doctor, and I am preventing to act under government. For they are filing of the writ application late, content file is pending, not appearing there, and all these things they have latches. Now, my lord pointed out why only my latches housing, but they are having long money, so many latches can be. My we have a positive hope for the court always. Because we are fighting for the poor people.
We're fighting well, sir. Right.
We also expect well order. The order is not well, fighting well.
All right. No, please. Here, my lord.
Okay. It's the last hope for
This is also no. Here, my lord, this advertisement for the post of assistant executive engineer in the year 2015. He filed the case challenging the not shortlisting. He belongs to SC category, and he filed the application before the Odisha Administrative Tribunal, claiming that the person, those who got less mark than him, they have been called, but he has not been called. Initially, my lord, he has said that SC category candidates who secured 190, even they have called, but even though he has secured 218, he has not been called. But when subsequently, my lord, he said that SC category, women category, has secured 190 and she has been called, but he is SC male. He applied for the SC category candidate. He applied as he belongs to SC category and he applied on SC category. Now, my lord, what happened? The OPSC called twice of the vacancies. Here, my lord, in the SC category, my lord, the minimum mark secured is 2030, but he secured 2018. Hence, he has not been called. But fact remains, my lord, in your category, we have made it separately. UPSC has formulated a circular that they will categorize the as per the caste. You are separate category, you are ST, SC separate category. Here, my lord, the SC category candidate last secured mark is 230, whereas the private opposite party he secured 218. Hence, he has not been called for to appear in the examination. He challenged that this time. But the Honorable Single Judge has said, since the your category candidate secured less than that, so he should be given an opportunity, and he should, and in case he is found suitable, he should be given that order we challenge. Here, my lord, in a uniform manner, we have adopted this policy, which has been approved, because there is no rule prevailing in the field how to shortlisting the candidates. But we in OPSC, we have in a principle, in a policy, has taken that no, we will for SC category, there is a sense they have applied for the SC category. The SC category will be
no, but that is against the whole reservation policy itself, sir. That's completely against the reservation policy. They may qualify better than the UR category, then we have considered quota.
This is a policy decision which has been approved.
No, it has to be consistent with the law, sir. It has to be consistent with the law. You see, the challenge in the present petition, in present appeal by the OPSC is to a judgment dated 17 May 2022 passed by the learned single judge, allowing lit petition civil (OAC 1359 of 2017) filed by respondent number 3.
Now the problem will be, my lord, 2015-16 recruitment. In the meantime, my lord, subsequent advertisement have been made for the post of.
There is a vacancy you could have considered in that.
There is no vacancy at all, because we have recommended the government have filled up last 7 years back. Yeah. So there is no, that point also we have in my ground I have taken in whatever the
but
other.
What has single judge said? Create a supernumerary post.
No, my lord has said, I may permitted to place. That is the problem. We will face the government also will face problem.
What relief can be granted?
Yes, my lord, may kindly have
2 posts vacant due to non-availability of SCBC. So he has asked that to be used for this.
My lord, we'll find from page 25, last portion, what the Honorable Single Judge said. This court is therefore of the considered view that the petitioner case deserves to be considered afresh by the opposite party number 1 by requiring is to hold a fresh interview, and depending on his performance in the viewers, further action be taken in the matter of the selected candidates, of course. This court is fully conscious of the fact that there may not be any vacancies at present. But when the constitutional right of persons seeking public employment has been grossly violated, it is for the authorities concerned to rectify such mistake by taking necessary remedial steps, including creation of supernumerary posts. If need be,
supernumerary.
That will create some difficulties, because no posts are available 2015. Even the tribunal, they have not got.
Whenever he files a contempt, you give that explanation. So let's see. We don't know.
Yeah.
Challenge the present appeal to an order dated. So allow disposing of that writ petition civil OAC number filed by respondent number 3. Paragraph.
I can indicate my averment that now the court.
Yes, yes. An advertisement was published by the Orissa Public Service Commission, OPSC. Being advertisement number 3 of 2015-16, inviting applications to the post of Assistant Executive Engineer (Civil and Mechanical) in Group A of Orissa Engineering Services. 657 posts were notified, of which 43 were reserved for SC category candidates. Paragraph. Respondent number 3 belonging to SC category applied for the post and appeared in the written examination. Stop. Candidates twice the number of vacancies were called to appear in the Viva OC on the basis of marks secured in the written examination. Stop. According to respondent 3, candidates securing less marks than him in the written examination were called for Viva OC, whereas he was not. Stop. Paragraph. According to respondent 3, as per the disclosed results, he had secured 196 marks in the written examination. And through RTI sought the marks of other candidates. Full stop. He noticed that SC category candidates securing 190 marks in both written and Viva OC were selected and appointed as AEE. Full stop. In the reply filed, OPSC pointed out that the lowest marks secured by SC male in the written examination was 218, whereas the petitioner had obtained only 196 marks. It is only the SC female category who had obtained 190 marks who was called for interview. In the course of hearing before the learned single judge, it transpired that the last candidate in the unreserved category, bracket UR category, had secured 196 marks, which was the same marks as the respondent 3 had secured, and therefore he ought to have been called for the Viva OC. Full stop. Paragraph. It was argued by the OPSC that it was their policy to call candidates only as per the cutoff marks for each category of reservation. And therefore, in his category, namely the SC category, since the last cutoff mark for male SC candidates was 2, was not called for the Viva OC. Full stop. The learned single judge has rejected this argument, following the judgment of the Supreme Court of India in Saurav Yadav versus State of Uttar Pradesh, 2021, 4 SCC 542, by pointing out that open quotation, unreserved category is not a category of reservation, but is open to all categories of candidates. Unquote. As a result, even candidate belong to the reserved category can compete in the category if on merits they score higher marks, same or higher marks than the UR candidate. Full stop. The above principle enunciated in the judgment of the learned single judge is unexceptionable and consistent with the settled legal position. Paragraph. It was then argued by Mr. Jaina, learned counsel for the appellant, that there are in fact no vacancies available against which the respondent 3 could be accommodated. Full stop. The learned single judge appears to have been with this fact and has accordingly directed that if after calling the respondent 3 for interview and he secures marks,
in fact, he has secured 218. The respondent 3 has secured 218. 218. Even the SC candidate 218 and the
No. Petitioner scored 196, sir.
196 is
yes. No. Page 23. Come to page 23, third line from the top. As already stated, by not preparing a common list, what has happened is that the petitioner, being an SC candidate and having secured 196.
Yes.
In the SC category, the cutoff was 218. This respondent number 3 got 196.
Man.
that if the respondent 3 qualifies after the viva voce, then a supernumerary post should be created to accommodate respondent 3. Full stop. This appears to be a justified direction in the facts and circumstances of the case. Consequently, the court is not inclined to interfere. The appeal is dismissed.
Supplementary list item 70.
Please, your lordship minutes. Lords, IA number 591 of 2022 is for. Lords, am I audible?
Yes, please.
Lords, here the appellant, who is the mother-in-law, had faced trial charged under section 498A, 304B, 306, 302, read with 34, and 4 of the Dowry Prohibition Act, my lords. And I have been convicted under section 498A, 304B, and 306 by 34 of the IPC, and I have been acquitted under section 302, 34 IPC, and 4 of the Dowry Prohibition Act. My lords, the appellant here is a lady of 75 years old, my lords. And your lordship had last occasion had asked the state to take instruction as regards the health issues as well as the grandchild which is living separately, because the appellant along with the appellant number 2, who is the son, they are both in custody.
Yes, please.
Instruction we have not obtained. Letter has been issued. Short date may be.
Mr. Katkia seeks a short adjournment for instructions on the antecedents, if any, and on the medical condition and other factors mentioned in the application. You put down this as IA number 519 of 2022.
No, it's 591.
591, is it? All right.
That is for bail of appellant number 1.
No, I think it is 519, sir.
519.
It's 519 only.
No,
this 520 is finest stayed. That's
519.
Right. List on 27th October.
Supplementary list item 71.
This second copy has not been solved. That the reason stamp reporting could not be made.
It's all right. I think we just say admit the LCRB requisition, paper books be prepared. This IA 536 that is allowed, stay of realization of fine. 537 not pressed at this stage. Disposed of.
Item 72.
Included in the list of final hearing matters.
The state copy has not been solved in this case.
The defects be cured in the meanwhile.
Well, 1 day time required for removal of defect, my lord.
That's all right. So you cure it in the meanwhile, you say admit the LCRB requisition. Paper, same order. You say defects be cured in the meanwhile.
Item 73.
Yeah, it's okay.
Up to 75.
Admit, same thing, same order. Defects be cured in the meanwhile.
Item 74.
Thompson.
There is a IF of fine that is disposed of, stay of fine.
Item number 74.
May I please? My lord, it's convicted, my lord, also 302 IPC.
All right, just say same order. Same order. The bail application not pressed at this stage.
Item 75.
Okay.
Same order.
May I please, lords? 75 lords.
Admit, yeah, same LCRB requisition.
And a miscase, my lord, bail may lie over so that it will after LCR.
No, but right now you don't press it, you can file afresh later.
Item 76.
Same order.
Item number 77.
Same order. 78. All defects be cured in the meanwhile.
78.
My lord, 1 week time I granted to remove all of it.
It's all right. You cure it within a week anyway. They admit same order.
79 also.
Same order. Correct.
Supplementary list for admission item 80.
May I please, your lordship? Petitioner belongs to my scheduled tribe. Is fighting this case more than 50 years. And at the learned single judge, on the one giving the findings, I kindly see page 24. This court, well, got page 20, got it.
What's the last order passed?
Regarding filing of the affidavit, regarding the plots, the proceedings plots.
Where have you
There are
filed
two
it?
proceedings.
Have you filed this?
That is regulation 1 of
Have you
95.
filed the affidavit?
Your lordship right to opposite party. I have to file.
I have to file the affidavit explaining the details of the plot number. I want to file it because I was constantly ill for about 2 to 3 months.
So this order was passed in December last year, sir. We are in October.
That's all right, my lord. So only 7 days time can you give so that I can, because you're a man of Sundargarh. That but also the cost title, they have not filed the cost title.
Counsel for the opposite parties seeks and is granted a last opportunity to comply with the order dated 6/12/2021 within 2 weeks.
Short deadline.
List on 16th November.
Is fighting this litigation for the 50 years. The schedule type person.
16th November.
Supplementary list item 81.
They be directed in item 80, they be directed to file the operate the cost title, incorporating the.
I have already filed the consolidated
Item 81.
The copy has not been solved on me, so let me directed to solve the copy on me.
Yes. May I please, my lords?
Yes.
The common judgment dated 6/20 of the learned single judge is challenged before your lordship. My lord, already the delay has been by order dated 18/3/21, and the 4 appeals have been admitted by order dated 24/6/2022. My lord, before going to the impugned judgment, a brief summary of facts, my lord, I want to place with your lordship's kind consideration. I've given a small date chart, my lord, with 4 or 5 dates. And 2 documents I would like to place before your lordship before going to the impugned judgment, my lord. My lord, on 1/10/87, the respondent was engaged as a daily worker of the Kolar branch of UCO Banks since 1/10/87.
You are appearing for all the respondents.
Yes. 4 appeals, my lord. The first one your lordship may take up for convenience. Common judgment was passed. Common issues of facts and law arise in all the 4 matters. 1/10/2004, my lord, the respondent was regularized by letter dated 24/1/2005 and posted as a peon at Kolar branch. In 19/8/2013, my lord, he made a representation to the general manager, Personal Services Department, Head Office, Kolkata, seeking regularization from anterior date of 1/4/90. Thereafter, on 31/2014, he filed the writ petition, and that has been allowed by common judgment dated 6/2/20. So before going to the impugned judgment, only 2 documents I want to show your lordship. First, your lordship, kindly see page 44. Page 44, the first case your lordship may take up. Page 44 is the appointment letter to the respondent. There I want to read out one paragraph at the beginning, my lord, which is very germane for this case. You will be paid a basic salary of rupees 2,750 per month and other allowances as applicable as per bipartite settlement and would be eligible for service conditions accordingly. You shall not be entitled to claim any benefits for higher wages or service or any other perquisites for the period you are engaged on a casual basis. So there, my lord, 2 things are there. One, based on a bipartite settlement, which applies not only to the respondent, but to casual workers throughout India. This appointment letter was issued. Secondly, my lord, there was a condition in that appointment letter that for the period you are engaged on a casual basis, you will not claim any other benefit. Then, my lord, I would like to draw your lordship's attention to page 40. Page 40 is the industrial settlement arrived at between the management of the UCO Bank and the other majority unions. At page 42, I would like to draw your lordship's attention 42(4), clause 4, empanelment. There is a clause in that settlement which I am reading out for your lordship considerations. Persons absorbed shall.
Right? This is stay order passed.
Yes, stay order is there. It has been admitted, my lord.
We'll list it for final hearing on some other day because we are at part third. We have.
Yes, yes, as my lords pleases.
List for final hearing on 15th February. Interim audit.
Item number 83.
My lord, 83, in obedience of the order dated 24/8/2022, the appellant has filed affidavit, my lord. Affidavit regarding valuation of the gold in the locker, my lord.
Is this exercise complete, sir?
Yes, I have a given copy.
1 minute.
Affidavit. I have attached a copy along with my affidavit. My lord. Affidavit of appellant.
Compliance is an order and why you're setting out provisions of the act. I'm not able to understand. Your memo of compliance, why is it setting out provisions of the act?
Yes, I have filed earlier, my lord. Provision of a law, my lord. In the Odisha.
How is this compliance? I don't understand. You have said compliance of order dated 3rd August and you're setting out provisions of the act.
Yes, sir.
How is it compliance? I'm not able to understand. In a compliance,
yes,
you're typing out all provisions of the act. How is it compliance?
My lord, Honorable Court part order directing me to file the provision of law wherein the ARCS has a power to.
Sir, have you complied with the directions issued by us?
Yes, yes. My lord.
Where is that? Where is the memo of that compliance?
My lord, I have already filed on 24/8/2022. Affidavit filed on 30th September 22.
May I intervene, my lord?
So the total valuation is 17,52,000.
On 24/8/2022, your lordship directed to value the gold ornaments kept in the locker.
Correct.
For direction, all the parties present before the in the bank premises, and the valuation has been made on 9th September 2022. And the entire valuation of the gold ornaments, as per the at present market value, assessed to the tune of rupees 17,52,000. The bank filed affidavit before the read court. The value of the gold ornament may 50 to 60 lakhs and submitted before this on court in this rate appeal around 3 crores. But in fact, it ascertained the value to the tune of rupees about 17 lakhs. And the writ petition has been disposed of with the impugn order before your lordship. The bank has submitted before the honorable single judge to operate the locker, my lord. They can have glanced to the impugn order, my lord. The honorable single judge quoted the relevant paragraph, paragraph 5 of the order dated 21st March 2022. May I read, my lord? The order dated 21st March 2022, where the bank considered he has no objection for operation of the locker since the ARCS passed order, the locker has not been operated. At this stage, Mr. Sahu submits that petitioner be allowed to operate the locker.
On query from the court, Mr. Ponda submits, though on behalf of Vigilance Department, submission made regarding the petitioner and her husband not being accused but his client relies on first information report dated 31st December 2020, wherein there is a clear allegation against the deceased husband of the petitioner, but recommendation of initiating criminal case against the other person since the petitioner died earlier 23rd July 2020. The dispute before the Honorable Single Judge is that the locker of the petitioner was not operated pursuant to the letter dated 24/7/2022, wherein the Assistant Register Cooperative Society Baleswar prepared to operate the locker with the presumption, with the reasoning that some counterfeited document may be placed in the locker. That is the reason of preventing the operation of the locker. Page 40 of the writ petition, letter dated 24/7/2020, which was subject matter of the writ petition before the Honorable Single Judge. And the reason for that purpose, to ascertain what are the contents of the locker, the inventory list has been prepared during pendency of the writ petition. And after inventory, nothing found from the locker with regard to connection with the investigation of the criminal case or with the society document. Only the material gold ornaments of a female is found, which has been inventory list submitted before the Honorable Single Judge. And on the basis of submission of the writ appellant, that they have no objection of operation of the locker, the Honorable Single Judge allowed the imputed. Now they are coming before this court with, after giving consent before the Honorable Single Judge, with that the operation of the locker cannot be permitted. And the valuation what they have projected 50 to 60 lakh ultimately found not correct, which is amount only 17 lakhs.
So this is by a valuer. I mean, whatever the valuer has done is okay. We can't sit in appeal over that. So if you have any objection to that, it has to be in some other proceeding.
No,
we just wanted to know what is in the locker and what value is that. And this is an accredited valuer, sir.
The order subject matter before the Honorable Single Judge, page 40 of the writ petition, kindly have plans. With reference to the caption subject, I am to say that you are well aware about the fact that Polpana SCS, a huge amount of misappropriation has been submitted in Polpana SCS by Pradipta Kumar Das, ex-in-charge secretary of Polpana SCS. It is learned that a locker facility has been availing by Sujata Das, wife of Pradip Kumar Das. A vigilance inquiry is going on in the matter of misappropriation. There is apprehension of counterfeited society document and assets relating to the misappropriation may be kept in the locker of Sujata Das. That is the reasoning of RCS to prevent me to operate that locker. So you are requested not to allow anybody to operate the locker maintained in the name of Sujata Das, wife of Pradip Kumar Das, till the finalization of vigilance inquiry and investigation. Vigilance department submitted before the Honorable Single Judge that they have no way related to the locker. The locker is not the subject matter of inquiry. There is no preventive order from any competent court of law to prevent the locker, except this order. And this order has been set aside as the reasoning found to be false, found not to be correct. No other counterfeited materials available in the locker.
My lord, total outstanding against the respondent number 1 is more than 6 crores. Dispute case pending under Annexure 8 before the Registered Cooperative Society Odisha.
Has she been served in that dispute? In that case, has this lady been served?
Yes, dispute case notice already issued.
Are they contesting?
Yes.
They have filed a reply.
No, not filed a reply.
So why are you not contesting that case?
That dispute case also filed a disposal of the writ petition.
No.
Then they can have page 55. How they are saying when the order of the Honorable Single Judge passed, thereafter they filed to avoid the overreach the order.
and I am not the service holder, I am not the servant of the society. I am a independent customer of the bank.
No. Husband of the wife, the respondent's husband was in service of the society. He has misappropriated, and the respondent number 1 has overdone more than 31 crore, 31 lakhs outstanding against his family, more than 6 crores, my lord. For which dispute case has been filed.
My lord, I have gone to the page 55 of the dispute case. The petition filed after order of the Honorable Single Judge, my lord. The Honorable Single Judge passed on April 2022. They filed May 2022 before the cooperative society, my lord, restored cooperative society. And they are saying that notice has been issued. They have not produced any kind of notice.
Notice issued and she has received it.
1 minute. You're the Baleshwar Bhadrak LP Cooperative Bank.
My lord.
Does this respondent number 1 have an account with you?
My lord.
Does respondent number 1
yes
have an account with you?
Yes, yes, my lord.
What is that account number?
My lord, document number 3 is the order of ARCS, and answer 4, 28 is the order of the branch chief executive of Baleshwar CCB. That was challenged before the REIT court. And Honorable Single Judge quashed only Annexure 3, page 27, order of the ARCS.
No. Does this respondent number 1 owe you any amount? Does respondent number 1 owe you any amount, or the husband owes you amount?
No, respondent number 1 has overdone 31,61,960 in his account number 2054.
His or her? We are dealing with the lady, sir. It is his account or her account?
Lady's account, my lord.
What is that account number?
Account number 2054.
No. She has an account with your Baleshwar society.
Yes, Bahanagar branch, my lord. Yes, Baleshwar Bhadra Central Cooperative Bank, Bahanagar branch.
And then who's this Panapana SCS?
Panapana SCS is a affiliated society, primary cooperative society affiliated to the Baleshwar Bhadra Central Cooperative Bank.
What have they to do with this litigation?
My lord, Panapana Service Cooperative Society availed a loan from Baleshwar Bhadra Central Cooperative Bank.
Okay.
And invest the loan to the farmers. And the said society paid the loan dues with interest to the Baleshwar Bhadra Central Cooperative Bank.
Okay, what have they to do with this? All this litigation, what has that to do with this?
The husband of respondent number 1 is originally of the Baleshwar Bhadra Central Cooperative Bank. He was in charge secretary for time being on as a under deputation.
No. What is this Panapana to do with all this?
Panapana, my lord, is a primary cooperative society affiliated to the Baleshwar Bhadra Central Cooperative Bank. The husband of the respondent number 1 was in service, in charge secretary, and
of which?
Yes, in the Panapana Service Cooperative.
For that, to say that you are struggling so much.
Whatever my senior submits, that is not in their counter affidavit, not before the reading the writ appeal memo.
Yes, I have mentioned in my writ appeal.
Nothing they have disclosed.
Yes, I have mentioned everything.
Rather, they have agreed for operation of the locker, my lord.
No. I have never agreed. My lord, I have.
Order that can have para 3 of the order.
My lord, I have mentioned para 3 in my writ appeal. That the husband of the respondent number 1, page 4 of my writ appeal, that the husband of the respondent number 1 was working as in charge secretary of a Panapana Packs oblique SES with effect from 26/11/2018 to 31st March 2020, and he has misappropriated amount of rupees 6 crore 36 lakhs 28,000 during his service period, and said amount are in collection loan of money of the farmers. Similarly, during tenure of Aditya Kumar Das as in charge secretary of Panapana SES Limited, he had opened SB account number 2054 in the name of his wife Sujata Das, respondent number 1.
What is the progress in the criminal case? Any criminal cases been registered?
Criminal case, my lord, that has been progressed, but the petitioner's husband not an accused. The petitioner is not an accused.
Petitioner husband already expired.
Not before the expiry.
Is the respondent number 1 an accused?
Not an accused.
And respondent number 1 is not accused.
Then on what basis can you locker?
The total amount to 30 lakhs 61,000 against the respondent number 1. For which the government officer ARCS opposite party number 4 here in the respondent number 4 has issued a letter not to operate the locker.
You're contesting that proceeding in before the Registrar of Cooperative Society.
If I have received the notice, then I will contest. There is also no order of attachment like to.
No. What we'll do is we'll say status. Now that in your presence the locker has been opened, it is safe back in the locker.
Yes.
So let that continue till the proceedings in the society.
Yes. That is my personal property. That is not the asset of the society.
That they'll have to investigate, sir.
They have to. If they have to raise a question before the competent authority, and they have to justify some dues is recovered from me.
They say you've overdrawn to the extent.
Yes, that is also a false statement.
No false. That is a public institution, never state false statement. The secretary is a public servant.
They may file an affidavit to that effect. In the writ appeal, they have nothing. Before the honorable single judge, they have nothing said about
writ appeal. I have categorical mention.
In the before the single judge, they have nothing said about the outside. And now new fact there is by oral submission. This is your account number. This is your
oral submission. I have read over.
Produced account statement within
3761,961. Para 3, it's clearly stated, overdrawn.
Yes.
3761,961.
I will file an affidavit, my lord. I will give a reply to that.
You say compliance affidavit has been filed on 29th September 2022, enclosing the details of the inventories of the articles in the locker in question, in the bank locker in question. Stop. The total value of the said articles is as estimated by an accredited valuer is rupees 17,52,180. Stop. Counsel for the appellant points out that proceedings against respondent number 1 stand initiated before the Registrar of Cooperative Societies.
Dispute case number 75 of 2022.
By way of dispute case number, where have you mentioned this?
My lord, Annexer 8, page 52.
Case number
order of the
75/2022. Full stop. It is stated that notice in the said application has already been served.
Yes, my lord.
On respondent number 1. Full stop. Paragraph. And a specific averment has been made in para 3 of the writ appeal that respondent number 1 has overdrawn a sum of rupees 3761,961 to her SB account number 2054.
I will give a reply.
Stop. Counsel for the respondent number 1 states that he would like, in view of the above averments and documents, he would like to file a reply. He is permitted to do so within 4 weeks, rejoinder, if any, before the next date. interim order to continue. List on 15th December.
Item number 84.
May I please, Your Lordship.
Reply.
Your Lordship will kindly recollect, this is a public interest litigation questioning the transfer of Gochar land in favor of IDCO, who in turn has transferred the same in favor of the DAV school. Now, my lord, so far the initial PIL is concerned, it was in respect of two plots, namely 1971 and 1973. Now, in the counter affidavit, they having clarified that 1971 is not proposed to be alienated. Now, it has been confined to 1973. That Your Lordship has been pleased to clarify. Now, my lord, so far as this writ petition is concerned, Your Lordship will kindly see our primary contention is that, my lord, I'll also bring to Your Lordship's kind notice certain pleadings also from the record to fortify my submission, and Your Lordship will find, in fact, for de-reserving the land, the procedure, the law that is required, which Your Lordship also mandated in order dated 14/7/2022, has not been at all done. Least to speak of anything being done. That was the mandate in order dated 14/7/2022. And before bringing that order to Your Lordship's kind notice, I beg to place certain facts for Your Lordship's kind consideration. And if I can convince Your Lordship that there has been no procedure adopted so far as the de-reservation of Gochar land is concerned, then the entire consequential action will become void and nullified in the eye of law. So that is what I will submit it for Your Lordship, my lord. Now, my lord, Your Lordship will, may I just, with Your Lordship's kind may I draw Your Lordship's kind attention to paragraph 6 of my original petition itself, wherein I have specifically stated that no procedure has been adopted while allotting a Gochar land in favor of DAV. That is the contention, and Your Lordship also will kindly peruse the ground. I have specifically in ground number 2 at page 7 specifically stated that the provision of OGLS Act, I think my learned senior appearing for the state will also agree that that is the only provision under which a Gochar land can be de-reserved, and post facto that question of alienation by IDCO in favor of DAV school will arise. Now, that was the contention. Now, counter affidavit was filed to this writ petition, and Your Lordship, before that, I beg to draw Your Lordship's attention to Annexure 1. I may be pardoned, this is in Orissa, but fact remains plot number 1973 at page 11 is Jhaun, and the Kisam is Gochar. I have filed subsequent documents which Your Lordship has been pleased to take a note of. Now, here it is Jhaun because under Annexure 2, Your Lordship will find the inhabitants of the locality, the government entered into an agreement for development of forest, and this petition number 4 for Your Lordship was the chairman of that committee, and they have developed this Jhaun jungle over this Gochar land. And that also is subsequently admitted in
change to Kisam Bagayat 3.
I'll submit on that.
When was that change brought about?
But that change has taken place post facto 1977 in the consolidation record.
During the consolidation
I'll just clarify. The consolidation authority, that is what is the crux of the issue. The consolidation authority are not competent to do that, and there has been no order. So to Your Lordship,
that happened more than 45 years ago.
I'll just point out to Your Lordship one thing. Your Lordship's specific order, and it has been held by the Honorable Appeals Court, my lord. Even after 27 years, a non-nest order remains a non-nest order, and the invalidity of the same can be pleaded at any stage, any proceeding. I'll just point out what has happened. There has been no order at all. That is what I beg to point out. If Your Lordship will find, even there has been a consolidation order also. I'll sit down. Your Lordship will see there has been no order at all. I beg to humbly submit that there has been no order at all. Your Lordship may kindly see the affidavit filed by them. Counter affidavit that was filed.
Mr. The only difficulty in these kind of matters is if you come to the court after 45 years.
No, we have not come after 45 years. May I just clarify? This transfer in favor of DAV school took place when they tried to. My learned senior will answer. I'll just, because if he interrupts time and again, I may not have that. I'll just put forth my point for Your Lordship's kind consideration. When they try to uproot those Jhaun plantations because of the post-fact allotment, then only we came to, and it came out in newspaper.
So we continue tomorrow. Because it's already 4:15.
Tomorrow.
We had one criminal matter. I don't know if she's ready.
My lord,
No, I was in fact thinking of praying for tomorrow, but I know my learned senior will oppose, so therefore I placed
no,
it.
I pray that
My
let it
lord.
be listed in top of the list. So that
My lord, as item number 1 also, because it will be my privilege also, my lord.
We'll take it up at 10:30.
My lord, I have no objection.
Yes, my lord.
I have
Yes,
no objection.
I am there from 10 o'clock, nothing.
He is there from 10, I'll 10:30.
All right. All right.
And the
We'll call it out first.
interim order was
Say at 10.
interim order was there, may kindly be extended.
Today and tomorrow, absolutely nothing
It's
should
there.
happen.
Do you think that tomorrow we will construct?
Obliged, my lord. Obliged.
Call it.
Supplemental list pastor matter item number 16.
Item 16, my lord. Kindly pray for tomorrow if today.
16.
Yes, my lord, 16.
Why should we keep adjourning? What is the matter about?
Here I have challenged the order of the Honorable Single Judge, my lord.
My lord, this is relating to 24 hours medicine store inside the medical campus, I think. That is no more in existence. That policy has been changed. Yesterday, I was arguing before your lordship that government has changed the policy, will not grant any license to operate the 24/7 medicine shop inside the medical campus. So this has become infructuous, more or less.
No, that part was considered before the Honorable Single Judge, and it was decided that the matter has not become infructuous, my lord.
No.
Yes, my lord. That is there in itself in the order, my lord. That finding the Honorable Single Judge has given. At page 21, para 10, my lord.
No, last paragraph, paragraph 23 of the impugned order.
That is a different ground.
I'm only concerned with that part of the order, my lord. I'm not challenging the order in entirety, my lord. I'm only challenging this part where the Honorable Single Judge has directed, while setting aside the impugned order and granting the order in my favor, I'm only concerned with this part, my lord, wherein the Honorable Single Judge has directed the state to conduct an inquiry over the certificate of
Yes,
mind.
it is clearly mentioned in paragraph.
Yes, I'm only concerned with that.
That's correct only. That's correct. Is there no stay, no, here?
No, my lord, no stay order.
Then that order must have been complied with by now.
I don't have up-to-date instructions, my lord.
That's all right. The challenge in the present petition appeal is to a limited is in a limited sphere, in as much as the challenge is only to one portion of the impugned order dated 17th August 2016, passed by the learned single judge in writ petition civil 12270 of 2012, filed by the present appellant. Full stop. While disposing of the writ petition and directing that and setting aside
that impute order is at page 32, my lord, Annex 3.
the order dated 2nd July 2012, cancelling the rec license issued in favor of the appellant. A direction has been issued in para 10, is it?
Direction, my lord. Direction at page 30, paragraph 23, my lord. 22 and 23. Page 21 of the...
Yeah, it only says you will not be entitled to seek renewal.
Further, the Honorable Single Judge has directed to conduct an inquiry.
That direction, an observation has been made
After quashing
that the quashing of the said order would not preclude the state government from inquiring into the genuine qualification of the appellant, basing on which he was registered in the Pharmacy Council of Orissa as a pharmacist on reciprocal basis. Paragraph, there has been no stay of the impugned order of the learned single judge during the pendency of the writ appeal. Full stop. Clearly, if the inquiry has not yet been conducted, it cannot now permitted to be conducted after a lapse of 6 years. Full stop. To the limited extent, it is directed that if no inquiry has been conducted so far, it shall not be conducted hereafter.
Obligation.
The appeal is disposed of.
Pastor matter item 25. Item number 25.
Respondent. I'm also for the respondent.
None appears for the appellant despite a pass dismissed.
In the order.
Item number 35, pastor matter. Item 35.
May I please? Yes, please.
Already. It may be lordship may can take taken up tomorrow, my lord.
This will take time.
My lord, it will take time.
At the request of counsel of the appellant. We'll have it next week. List on 20th October.
Six hearing matters.
Call it.
For hearing item number 85.
Item number 85, my lord. The double murder case, my lord. It will take some time, my lord. Are the
two injured eyewitnesses are there.
And I don't care, my lord. I know. But my lord, the immediately issued by the bail order recalled by this lord. Thereafter, they have taken to custody, my lord. Now they are all three appellants are in jail custody, my lord.
We can take it up tomorrow, sir.
Tomorrow, they next.
Okay, day after.
Tomorrow, my lord.
No, tomorrow. Day after is Friday.
Tomorrow.
Tomorrow. All right. Tomorrow.
Item 86.
86, my lord. I have not received paperwork. By tomorrow, I will receive any date, my lord. I will do, my lord.
All right. At the request of counsel, the appellant. This person is in jail.
Person, no, he's on bail, my lord.
He's on bail.
Well,
6th December.
Item number 87.
67.
87.
Keep this matter any other date, my lord. Keep this matter any other date.
All right. List on 8th December.
Item
At the
number
request of counsel, the appellant. List on 8th.
Item 88.
May I please, your lordship? I want to pray your lordship to consider the 389 application, my lord. If your lordship.
No, we'll take it up. We'll hear the matter itself.
My lord, in this case,
If you're ready, we'll hear it on 27th or 3rd November. List on 3rd November.
In this case, my lord, my name is deleted, my lord.
Or
consent already.
the name of Mr. Ragada be deleted.
I am submitting, my lord, the appellant is 70 years old, suffering from some.
We'll hear the appeal itself. That's why. We'll hear it on 3rd November. That's an early date. All right.
Item number 89.
No, 3rd November.
Item 89.
My lords, item number 89, I am appearing in the sub-item, my lords. That is CRLA 252 of 2007.
89 you see list on 15 December.
Item number 90.
January. So we'll take it up tomorrow. All right.